manner. There's a settlement that is
Settlement is going on
possibility of settlement.
Possibly until last
Yes,
day.
Manoj, will it some
After
time?
the vacation. Okay.
after vacation.
After the vacation.
Mr. K. Talukdar, learned counsel, appearing, one of the learned counsels appearing for the petitioner side, submits that efforts at settlement of the matter is going on and has progressed also, and prays for posting the matter after the reopening. Full stop. You are for the other side.
For the other side. MDAS.
MDAS. And learned counsel for response number 2 concurs with the said submission. Leave the matter after 4 weeks.
Yeah, please, Your Lordship.
On a date to be fixed by
Interim to
registry.
continue.
Interim order
in-
shall passed by so date shall stand extended till the next date of listing.
May I please, Your Lordship?
I'm grateful.
The concern of the other side. With the concern of the other side, beg to mention item number 2, Lordship.
Item 2,
Item number 2, Lordship.
transfer petition.
It will be after vacation, Lordship. 27th of July, if not.
Full stop. You are for the
I'm for the petition. Lordship.
petition. Learned counsel submits that the matter may be posted after 4 weeks and that he has taken the consent of the other side. Full stop. List on 27 July,
27
27/7.
Lordship, there's the interim order.
Interim order stands by so and so date, stands extended till the next date of listing.
Please, Your Lordship.
Madam, please.
Lordship, I beg Lordship indulgence in mentioning a very, very urgent matter, Lordship. May I pray that this matter will be taken up as a product, be taken in the production list, my lord. Because the petitioner was in interim and he went to police station for recording his statement.
Today itself.
Today itself, Lordship. At Lordship.
Please, Your Lordship, with the consent of the other side, I beg to mention item number 5, Your Lordship.
Item 5.
Yes, Lordship, the matter may be taken up after vacation.
Your good name, please.
P. Upadhyay, Your Lordship.
You by the learned counsel. You're for the other side, customs.
Yes, Your Lordship, appearing for the customs.
Learned counsel appearing for the customs department. Submits that a matter may be posted after 4 weeks. And that she has taken the consent of the other side. Full stop. The prayer is allowed. A list after 4 weeks. Should we fix a date?
Yes, Your Lordship, date may be fixed.
List, you give a date after 4 weeks. List on 17. 17. Any interim orders there? No.
Not
no,
that I'm
no.
aware.
Hi, Lobo. Just check it once.
May I please, Your Lordship?
Obliged, Your Lordship.
Lordship, I'm mentioning item number 32. CD has not been received yet.
32.
32. Lordship, after vacation. And
Yes, there is not received. Issue 32. Yes, there is not received. Issue reminder for the same. Interim order is there.
yes,
Stands extended till the next date of listing. List on 16.
16. Delayed by one.
May I please, Your Lordship? So I beg to mention item number 24, Lordship.
24.
I have been interim for the last 1 year, Lordship, but
Oh.
I've been told that a charge sheet has been filed. But for the last 1 year, I was in interim.
Yes.
Item
Let's-
24.
Charge sheet is- Let's take it up. Dispose it of. No need to adjourn, I think. We'll take it up.
May I please, Lordship? Lordship, I like to mention it for listing for tomorrow, Lordship. It's a bail. Obliged, Lordship.
Lordship, I have a similar prayer because
Bail matter.
yes, my lord. For hearing, my lord, tomorrow other matters are fixed, my lord.
Bail matters.
Yes, my lord. Lord,
May I please, Your Lordship?
Ah.
Lordship, I beg to mention item number 47, Lordship. With the
Item
item number 47, Lordship.
47.
With the consent of the other side, Lordship. Matter may be fixed after the vacation, Lordship.
You are for the petitioner, the appellants. Counsel for the appellant.
Yes, Lordship.
Prays for posting the matter after the summer break and submits that she has the consent of the other side.
Yes, Lordship.
Prayer is allowed. List after 4 weeks on a date to be fixed by registry.
Lordship, there is an interim.
Interim order by so and so, it stands extended till the next date of listing.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 12 and 15. Lordship, kindly matter may be adjourned for the day.
12 and 15.
Yes, Lordship.
Are they connected or separate? Connected. Scan TCR is there. No? And in both same TCR.
Charge sheet submitted. CC called for earlier, charge sheet submitted.
I think 15 we can take it up and dispose of. It may be possible to allow also. let us see. 12 we can adjourn, right?
NDPS commercial quantity.
Commercial quantity charge. Oh, then we have to call for the scan record again. Anyway, we'll pass an order in the 12, in the 15, 12 to 12, Land Council 6 an adjournment of the matter to be posted after the summer break. Scan TCR is available. Prayer is allowed. List the matter on 20, huh? 207. Take the other one also 20 and 15. Charge sheet is submitted. Land Council 6 an adjournment of the matter. Full stop. However, the prosecution submits that in the meantime, the case has also been charge sheeted. Further submitting that the matter pertains to commercial quantity under the NDPS Act. Full stop. Accordingly, call for the scan TCR. Yeah, we'll call for that. It's different, no? This one is different.
Yes.
Call for the scan TCR of so and so case. Xylophone. Yes. Comprising case diary, charge sheet, and any other relevant documents from the
Circuit number 21/26.
from the learned court below. Okay. List.
21/26 dated 29/4/20.
This we are fixing it on 22nd. Huh? One is 20, one is 22.
May I please, your lordship? I beg to mention item number 36, your lordship. In this
36.
matter, we have filed an affidavit, your lordship, that may be called for the record.
Yeah. No.
Like, your lordship.
36.
May please, Your Lordship. Lordship, I beg to mention item number 4, with consent of the other side. We'll file an additional affidavit on the next day, Lordship.
It may be tagged today.
Lordship, may list after 2 weeks, Lordship, after
No,
vacation.
Not today. You're for the petitioner.
It is
Learned counsel, Mr.
I Hussain.
I. Hussain, learned counsel for the petitioner submits that an additional affidavit has been filed today.
Lordship, we will
which will-
file. We
Huh?
will file.
So you will file.
We will
Submits
file.
that the petitioner side wishes to file an additional affidavit and prays for 2 weeks' time. Prayer is allowed. List the matter after 4 weeks, after 3 weeks.
Good.
3 weeks on a date to be fixed by registry. Once you
May-
file, it will come.
May I please, your lordship, I beg to mention for item number 31, lordship, engaged counsel as soon as has personal difficulties today. So please, lordship, matter may be listed after vacation.
This is, let us see. Diary has come.
If there is a I will have to return with the.
Oh, the interim is there.
No, your honor, no lordship.
Why? After vacation.
Yes, lordship.
Mr. Good name, please.
A. Hussain.
Learned counsel for the petitioner seeks an adjournment and posting after the summer break. It is submitted that there is no interim order. The prosecution submits that case diary has been received. The matter pertains to commercial quantity under the NDPS Act. So you will return back the case.
Return with the signal.
The prayer for adjournment is allowed. The case diary may be returned and procured again for the next day. Fix on
21 or 20 the last part. 23/7.
23 years.
23.
Obliged, lordship.
May it please your lordship, I beg
Yes.
to mention item 34 of the daily list, your lordship.
34.
Yes, your lordship. Your lordship, the case diary has not been received yet, your lordship.
34 well, case diary not.
Case diary is not received. Issue reminder. Interim is there.
Yes, Your
Interim by so and so date stands extended till next date of listing. List on 27.
Obliged, your lordship.
7.
Be item number 6.
Last date also none had appeared. Mr. A. Rajkhwa. Earlier draft. None after some time. Well,
Seven and 48.
48.
May I
And
please, your lordship?
Just 7 and 48.
7, I'm appearing for 7 here, Lordship. And my learned friend must be appearing for 48.
Lordship, my senior.
Basically, your Lordship, the 483 application. The petitioner was arrested on 25/12/2024. That is about 1 year, 6 months and odd. Lordship, we have actually 3 grounds or technical grounds in this matter.
Lordship, I'm going to interrupt my senior here. My senior, Mr. Ezekiel, is not available today, Lordship. It will be difficult to
So already,
matter today, Lordship. And previously, Lordship, we were ready to take the matter, but they took time.
Okay, so
My senior is not available today.
not
And-
today, then have it tomorrow or day after, whichever is possible, because already, your Lordship, this was a long pending matter. Can
After
be
vacation,
disposed.
Lordship.
No, can it be? Why keep it after the vacation? He's not available only today. Can we to tomorrow, day after,
day
whichever.
after tomorrow.
Yeah.
Tomorrow we have fix some
No,
connected
uh-huh.
matters. Stuff. Yes, Manan. You, Vice Manan, learned counsel, petitioner. Full stop. You said learned counsel appearing for the DRI submits that with SC Kyle, senior counsel and standing counsel DRI is not available today and prays for some accommodation. Full stop. The scan record is available. This is the matter on 26. 26 is always risky, but still
Anyway, we'll try on that day.
we'll try.
Obliged.
দুটা আছে ন? I think it is 48 আছে ন? দুটা। Same order, no? In 48 also, same order. Item 8.
অলপ পিছত ল'ব। মানে item number 8 can it be taken up after some time, Madam? And we're going to be half officer A. Ahmed Malik, court number 8, Madam. That's deep published.
Number 9.
Okay, please, Lordship. Lordship, this is an NDBS commercial quantity, Lordship. So first of all, I would like to take the grounds of Lordship is 36B. Lordship, kindly come to the page number 19, Lordship. Page number 19, the arrest memo under 36 has not been attested by either by any relative of the petitioner or by any respectable person of the locality, Lordship, in the violation of safeguard laid down in the Honorable Apex Court case number DK Vasu case, Lordship.
NDPS commercial quantity 1.530 kg of morphine
Lordship,
from the
And what about the other notices?
inside the
Because otherwise, I will be, we'll come back to that issue which is pending tomorrow.
yes, madam.
Otherwise, 48 notices, okay?
48 notice.
48, 48,
Lordship,
48 notices, fine.
Lordship, regarding the 48 notice, Lordship, kindly come to the page number 26, Lordship.
Some grounds have been given. There's been
Page number 26, Lordship.
26 or 27.
26, Lordship.
Hmm.
26, the notice has been served on the nominated person, whom I don't know.
Hmm.
Whether the petitioner does not know or nor he nominated, Lordship. No material has been placed on record to show that the person has been nominated, Amiruddin has been nominated, Lordship.
No, they
So,
cannot.
No any record in the
Amiruddin,
case.
my lord. I will point out.
Nothing in the,
My lord,
nothing has been placed in the
those are
record,
question
Lordship.
of fact, my lord. Now the fact
No,
is
I
that
have to
Amon.
talk
You cannot take a hyper technical view also, but the
Yes.
thing is that nominated person, we have to see, how about fixing this matter tomorrow? Because this issue is coming again.
Yes, ma'am.
Same.
You'll say me fix it tomorrow. ma'am.
Because we are, this issue we are taking
Yeah.
up,
Otherwise, my
correct,
lord,
some
that-
connected matters.
Otherwise, my lord,
See, because this court will have to take a position on whether this
now
is.
difficulty is that my lord trial courts also my lord facing because they are conflicting because of these conflicting views. We also need a clear answer. My lord.
So, but the thing is that if there are two different views of a single bench, as we had discussed
Then
yesterday,
my lord, otherwise,
then you can take a view but refer it to the larger bench.
yes, my lord, otherwise it would be better that
You can
for
take
all-
a view.
for all of us that my lord matter. We also need a clear for them also it is good and for the trial court.
Yesterday we had a long.
Otherwise, my lord,
The single bench can take a view, but refer it to the.
yes, ma'am. Otherwise, my lord, there are other instances in which, my lord, cases were referred to the larger, but while considering this, at that point, yesterday, my lord, one argument was made that during, my lord, sending it to the larger bench, what happened to the regarding bail, but bail cannot be granted, my lord, in case of referring to the larger bench also, because not only one single case, numbers of places, large numbers of cases, huge quantity of.
But that will
contravents,
take,
my lord.
but constitutional bench has to be constituted.
But
They have
it
to
will be
hear.
considered by the larger bench, in respect of the bail also, that can be considered.
Anyway, something can be done anyway. So we'll see tomorrow.
Lord.
This matter. We heard the matter pertains to certain issues with regard to which some other bail applications have been posted for hearing tomorrow. Accordingly, list the matter tomorrow. That is, what will be the date? 25. Scan record is available.
Obliged.
You are paid.
He is in custody, Lordship.
Same issue, my lord.
Same issue. The 36
Violation of
ground of
36.
36 is there, Lordship. And notice your Lordship will find that page 56.
Everywhere, my lord, huge quantity of contraband.
And
Here
page
also one
46,
page to
subject to
40.
correction, what my learned friend says, Lordship. From the certified copy which is annexed with the petition and which was provided to the petitioner, here in fact the petitioner's signature is also not there. I do not know if it is there in the main record or not.
The arrest memo.
Lordship, page 56. So if it is, the signature is not there, then completely six was not followed. Even if I admitted their argument also, Lordship. Page 56.
You want?
Page 56. Certificate copy was silent. They are not listened. You have to. 80% of the
No signature.
accused signature is also not there.
You have to check from the records. So again, same issue.
Same issue.
No, this probably will be different because they are saying, Lordship, that accused persons was informed and family members were informed through 48 notice. Here accused was also signature is also
Earlier,
not.
in earlier cases, their argument is that partial complaints, and now, my lord, total.
No complaints.
Total, no
So that will violate.
Yes, my lord. Then I will have to cross check, my lord, from
You
the.
will check from the records. Check
I
from
will
the
also, I may be allowed to
Yellow
go
tape
through
will
the
fix it
records.
tomorrow, my lord, then I will point out.
After some time, I will also go through. If it is not there, it is
Let
not
him,
there.
well, store.
Mr. Ahmed submits that in this case, the arrest
Lordship may
memo
take it up after some time. I will go.
did not bear
And
the
in case of
signature of.
total non-compliance also, my lord, that point also, my lord, regarding 36, because
No.
argument is regarding compliance of 36, that
Mhm.
also, my lord, I will have to.
Does not bear the does not bear the signature of witnesses or even the accused
In the certified copy.
/ arrestee. Full stop. The learned prosecutions, the learned additional will be submit that aspect has to be cross-checked from the records. Full stop. This is the matter tomorrow.
Yes.
Scan record is available. We can pick up these matters in the second half tomorrow.
Yes.
From 2.
Yes, sir.
We plan it like that, right? Finish for as much as we can.
Our difficulty is that, my lord, after completing all this, so we are also getting very, my lord, short time to go through, my lord, all
No,
the
we'll
days.
we'll
I will point
learn
out,
it
no.
and discuss it together.
Lordship may mention. in the order.
First half we'll finish whatever matters are possible. And second half, 2 o'clock, we can start and
Yes.
complete the hearing.
Lordship may mention in the order also that at 2, Lordship. Lordship may mention in the order also at 2. That will.
That's true. Others I have not mentioned this.
Obliged.
Only problem is the approaching break.
It will come.
May I please, your lordship?
Yes, this matter.
Lordship,
Item, which one?
item 10, lordship.
10 more.
Lordship, in this
Same,
matter,
same
we
problem.
prayer as well as lordship, we filed our objection. There was a little defect in the objection, lordship. So we have to rectify that defect. Lordship may take this matter after vacation, right?
No, Lord, I have got strong objection, but I am 1020 days behind the bar without trial. and they have examined two witnesses, they have not supported the case of the prosecution. Now they are saying that we have submitted an objection that is wrong. Now they are broke up from that trip. Can it be under the stress of my life, my lord?
Anyway, so we can take it up on Friday. That's the only option.
Difficult, Lordship.
Yes.
Right after vacation, Lordship.
No. Strong object. No, I cannot. I will not agree.
The
They're always
department-
taking the time, my lord. Always.
It is submitted by Hussain Learned Counsel.
My
appearing
detention is 1020 days.
I'll record that. DR submits that though an objection was filed on behalf of the prosecution, but there were some defects which have to be rectified, and praised for listing the matter after the break, after the break, full stop. Ensuing break, full stop. On the other hand, Mr. Biswas, Learned Counsel for the petitioner, objecting to the said prayer, submits that the petitioner has been in custody
1020 days.
in excess of 1000 days. And in the trial, so far only 2 witnesses have been examined, and that these 2 witnesses have not implicated him. That's
Yes.
full stop. So from my side, what you're saying, you'll file a fresh objection or correct it?
We have corrected it. We'll be filing today.
Then all right, day after
Mr.
tomorrow.
Hussain, Learned Counsel submits
Or
that
tomorrow.
corrected objection is ready, but it remains to be filed, full stop. So let it be, let us take a chance on Friday. Okay, leave the matter, because it's
But it's day after tomorrow.
day after tomorrow. Suppose not, submit straight. Day after tomorrow, Friday, this one.
Made please, your lordship. My lord, here your lordship's a regular bail, my lord. My lord, here charge sheet has been laid, my lord, citing 7 numbers of witnesses, my lord. Now your lordship may have a look at the FIR, my lord. That is at page 13, my lord, 13. Well, the second paragraph, my lord. During NACA checking, one motorcycle bearing number so and so.
Page?
Page 13, my lord, the FIR 13, my lord.
Nila pencil, blue pencil, blue color. No, pen, blue pencil. Pencil. Look at blue tag. Sorry, during NACA checking.
Yes, my lord. During NACA checking, one motorcycle bearing number so and so have been intercepted and apprehended the rider, namely Hanif Ali. That is before your lordship, my lord. So and so, my lord, was with him. Before conducting search on the apprehended person, we have called the local people of that area and requested to be a witness during the process of search on the body of the apprehended person and the carry bag which was carried by him. Also briefed the local people regarding the circumstances of the body search, and they agreed to be witness in the whole process. Upon conducting searches, the apprehended person and the carry bag, it was found that a total of 15 numbers of boxes, each box having 6 numbers of strips, each strips having 24 numbers of tramadol, so and so, my lord, number so and so, in total weight 1274.4 grams were contained inside the blue color carry bag. My lord, this is the case, my lord. Now, this paragraph, my lord, the last line, my lord, last 2 lines, my lord, a notice under section 50 NDPS was also served in the apprehended accused person, informing of his right under the NDPS Act, my lord. So, my lord, I have gone through the record, my lord. There is no notice as such under section 50 of the NDPS, my lord. Here, my lord, now the charge sheet has been laid that I have annexed, my lord, in my additional affidavit that starts from page 32, my lord. Page 40 is the, my lord, the brief facts of the case, my lord. Here also, my lord, the 3rd paragraph, my lord. Last 2 lines, my lord. Page 40, my lord. Lordship got it, my lord.
Yes.
Page 40, my lord. 3rd paragraph, last 3 lines, my lord. Notice under section 50 of the NDPS Act was also served to the apprehended accused person, informing of his right under the NDPS Act. All the procedures were duly were done via videography through e-Saksha app, my lord. So, but going through the record, my lord, there is no notice under section 50 of the
It was, if it is recovered from a bag,
bag.
then 50 may not be necessary.
My lord,
But if it's from the body, then it will be necessary. In fact, that will be,
vehicle,
there's a strict compliance.
My lord.
50 is absolutely mandatory.
my lord.
It seems bare. So that has to be seen. It is charge sheeted otherwise.
my
I stated, my lord, here
But the problem is it is
Next-
commercial quantity.
commercial quantity from his conscious position, my lord. And next date is already over, my lord, 19/5/2026,
State of
consideration of
Rajasthan.
charge.
So charge not framed, yeah?
my lord.
Letting place this, my lord, argument before.
Lord,
at the time.
I have not completed yet.
Oh, okay.
Well, I am relying upon a judgment of the apex court, my lord. That is state of Rajasthan versus, my lord,
Regarding 50.
50, my lord.
No, but the thing is that we have to first see it was recovered from where as per the charge sheet.
Exactly on that point, my
No,
lord.
no, no. Recovered from where? From the bag or from his body?
Exactly, my lord. On that point itself, my lord, I am submitting, my lord. The lordship may have a look at this judgment for a once, my lord.
Yes, so.
My lord. Yeah.
Yeah.
Detail.
If it is from the body, 50 will be.
No, my lord, I think, my lord, some of one, my lord, the lordship kindly take up the case, my lord, state of Rajasthan versus Paramanand, my lord.
From body, it is necessary.
Yes, my lord, that is there, my lord. That's why I'm, my lord, state of Rajasthan, lordship has taken that one. Paragraph 15, my lord. Page number 351, my lord. It says, my lord, thus if merely a bag carried by a person is searched without there being any search of his person, section 50 of the NDPS Act have no application. But if the bag carried by him is searched and his person is also searched, section 50 of the NDPS Act will have application. In this case, respondent number 1, Paramananda bag was searched. From the bag, opium was recovered. His personal search was also carried out. Personal search of respondent number 2 was therefore, in the light of the judgment of the court mentioned the proceeding, section 50 of the NDPS Act will have application, madam.
No, but the thing is that if it see, there are also judgments which says that if there are two parts of the prosecution case, one is recovery from body, one is recovery from the bag carried by him, and there is non-compliance of section 50, then one part of the prosecution case only will fail. And the recovery, if it is proved from the bag, will succeed, will not fail. Because 50 appears specifically from the body. It's Baldev Singh is we just have to see Baldev Singh.
Yes,
That's
madam.
Constitution bench.
Yes, madam.
Right. Anything else will be par incuriam because it's the 1999 Constitution bench.
Madam, this is
Okay.
and this one is of 20.
So we have to see, kindly, you will let him complete.
Yeah.
Senior counsel will complete. So we have to see that, let us read this again upon, because if it's from the body, it will be definitely
Yes,
necessary.
my lord.
With body search and so upon personal search of the, let us read from here. Upon conducting, please read second paragraph of page 40.
Yes, madam.
Let us be clear.
My lord.
You know, I may be wrong, but this is
madam.
a new thing I've.
Every day is
This is a new thing I've found that if you are searching body as well as the bag,
my lord.
then 50 would be applicable. In my opinion, 50 will be applicable to the body part of the search,
My lord.
not the bag. But
My lord,
it's
here,
like,
my lord.
like this, but it's a Supreme Court decision. Anyway,
Third paragraph, my lord.
yes.
During,
You can read from there.
During NACA checking, one motorcycle bearing registration number so and so have been intercepted and apprehended the rider, namely Hanif Ali of so and so, and one blue color bag, Pritam footwear, was with the apprehended person. Before they conducted a personal search on the apprehended, they have called the local people over the area and requested to be a witness in that body search, and also brief about the local people regarding the circumstances of the body search and allowed the witness to be searched her body. Well, it is a copy paste. It should be his, my lord. Her body by the local woman. The police has, my lord, copy paste over there, and accordingly they have searched her body. Upon conducting a personal search of the suspected following due legal procedure, a total 15 numbers of box, each box having so and so, my lord, were recovered from the bag, my lord.
Recovered from the 50 numbers of bags. Total number of box, each having so and so, each strip so and so, so and so, so and so. In total, one full color bag. Seized. Okay. So
My lord, the judgment which I have produced.
seizure is from the bag or from his, no, it has to be from the body, suppose.
Body.
You know, pocket. Pocket will be a good example. Short pocket, pen pocket, that will be body.
My lord.
That will not be bag, that will be body.
My lord.
But anything carried like this also?
My lord, in the hand also.
My lord,
In a vehicle also, my lord.
Yes, please.
and that Rajasthan judgment, my lord, has been followed by, my lord, in another case, recent one, my lord. It has been delivered on 16th of March 26, my lord. That is, my lord, state of Himachal Pradesh and versus Surat Singh, my lord, where the state went to the apex court on appeal, my lord. And the apex court, my lord, relying that judgment of the state of Rajasthan, my lord, had dismissed the application of the state, my lord.
See, we can also look at it this way. We can also look that whenever his body is searched, 50 will apply.
Yes.
No doubt.
Yeah.
His body cannot be searched without giving in the choice of
Right.
50.
50.
But whether, suppose there is non-compliance, whether the non-compliance of 50 would be fatal or not, I think, in my humble opinion, it will crucially depend on where from the recovery was. If it was from the body and 50 is not recovered, certainly it is fatal.
But 50, there are only two
But
options.
if the recovery is from the bag,
Bag, my lord.
and his body is also searched, and it is recovered from a bag carried by him, then non-compliance of 50 should not be fatal,
My lord, my lord.
as per Baldev Singh
Right.
and many other
So
decisions.
Lordship may fix another date, my lord, let him come with a.
But already, we time constraint to treat it.
Right.
Anyway, so it's not clear from here. And he can throw light some more light.
And
So according to you, though, it was from the body.
but
And maybe the bag along with the body which was searched, and therefore in terms of this, it is fatal.
and so far 50 is concerned, my lord, there is only two options, either before a gazetted officer or before a
50
magistrate.
is absolutely strict.
There is no third option of the local
no,
witnesses.
no
No third
substantial.
option, my lord.
Baldev Singh itself has made it clear.
My lord.
Section 50, unlike 41, 42, there may be question of substantial compliance.
My lord.
But 50, there is no question of substantial compliance. It is strict compliance.
My lord. And ultimately the trial was vitiated, my lord.
Yeah, 50 is strict compliance.
My lord.
In my opinion, body, third pocket, pen pocket, definitely it will be applicable in case of a male or something. But only exception with regard to a bag where 50 may be applicable is with regard to money bag. Suppose a purse is found in his body search, and there inside the purse some heroin is found. Then you cannot say that he was carrying the bag, because you cannot search the money bag purse without searching the body. So there may be, but if it's a bag carried by him, it should not be, as far as I have understood. But anyway, we are constantly learning. So can I go to him?
My lordship may go to him, my lord.
Kindly, from the record, because from this paragraph it is not clear where exactly it was
My
recovered.
lord.
His body was
Okay.
searched, bag was searched, but from where it was recovered?
No, my lord.
Kindly see.
Here, my lord, page 14, my lord. FIR forwarding, my lord. Background of the case, my lord.
Just give me half a minute.
It's 14 of.
Page 14, my lord. Here, my lord.
Just give me half.
On the program.
Okay. Anyway.
My lord. First of all, my lord, page 14, 1, 2, 3, 4, 5, 7, my lord. During Naka checking, my lord.
During Naka checking.
My lord.
Yes.
One motorcycle bearing registration number so and so have been intercepted and apprehended a rider, namely Hanifali so and so, Gwalpara, and one blue color carry bag was with the apprehended person, my lord. With the apprehended person, my lord. Before they conducted a personal, that is thereafter, and lordship page 17, my lord.
No, continue.
No.
before they conducted a personal search on the apprehended, they have called the local people
Really?
over the area
No.
and requested to be a witness in that body search. Also brief the local people regarding the circumstances of the body search and allowed the witnesses to
On the body, search on the body of the apprehended person and the carry bag,
My
which
lord.
was here, it is more clearly written anyway.
My lord.
But charge sheet also briefed the, you read this, also briefed, go on reading.
Well, upon conducting a personal search of the suspect following due legal procedure, 15 numbers of boxes, case box having 6 numbers of strips, each strip having 24 numbers of tramadol hydrochloride, daclomine, hydrochloride, and acetaminophen capsule so and so. Total 2160 numbers of capsule. Each capsule so and so. Total what? 1274.4 grams, madam. Blue color carry bag and black color polythene bag, and also one black color, red color TVS bike, my lord, bearing number so and so.
Here it is more clearly written that it was recovered, so and so was recovered from inside the blue color carry bag
My lord, that is well.
and they were seized.
My lord.
Here it is more clear, but charge sheet they have written in a confusing way.
Lordship is rightly
Should
pointed
we
out. my
complete or you, should we keep it for,
let us next one.
keep it for another day?
For another day, madam. My lord, so
You can also look up a
My
little
lord.
bit.
the apex court says, my lord, if your body search is made, you have to.
Yeah,
comply.
follow, but if the recovery
My
is
lord,
not
the
from the
doctrine is
body,
rightly pointed out.
uh,
my lord.
that
No,
may not be there.
Big, my lord.
But yeah, this is
But-
true that when before body search, 50 has to be complied. Otherwise, anything we can say like that. If body search from Baldev Singh, 1999 constitutional bench,
My lord.
if any body search is there, 50 will have to be complied.
My lord.
And if 50 is not compliant, and any contraband is found from such body search, then that recovery will be vitiated.
My lord.
But,
3 points.
My lord. Anyway, my lord.
Anyway, no, I mean, this is what you have understood.
My lord.
But if the law, interpretation of the law tomorrow, of course, the apex court can always say
Yeah, my lord,
this-
the
that
Rajasthan
plain
case,
reading
the
that
Rajasthan case says, my lord, if the bag carried by him is searched and his person is also searched, section 50 of the NDPS will.
yeah,
NDPS
that
Act
will
will have-
appear to the search.
Right,
But
right.
we have to see the facts in this. Let us take up the Baldev Singh
But-
again. We'll see the Baldev Singh again.
Next, my lord.
Exact language. Thereafter, there's a Himachal. I've forgotten the name.
Yes,
on
Sujit
5th.
Singh.
No, Himachal Pradesh, there's a big judgment actually. Pawan Kumar or something, something of that sort. HP on 50, which elaborately, discusses 50. If I'm not mistaken,
Right.
sometimes we mix up the names. On Friday,
My lord.
last day, some
Last day.
constraint, but still we can.
Or lordship may make it as a part heard, my lord, and lordship may take it after the vacation, my lord. I have no issue, my lord. Because Friday will be the last day, my lord.
Not, it is not.
We can fix it, but if time permits, we'll take it. Let's fix it.
Well,
Liberty matter. So
well.
if time permits, fine. Otherwise, we can always post it.
Because in this case, man, another point was taken regarding that section 36 also. Man.
That's Mr. N. N.J. Dr. Land Counsel, for the petitioner and his Horma Land Counsel. It is contended by Land Counsel for the petitioner that in this case, the body of the petitioner, the accused petitioner was also searched. And though there is mention of compliance with section 50, but the records do not indicate compliance with section 50 of the NDPS Act, which is mandatory. And therefore, any such search and recovery might have been vitiated, full stop. To buttress the said contention, reference is made to to the case of State of Rajasthan versus Parman, and attention is drawn to para 15 thereof. Para 15 thereof, which may be reproduced here in below. The learned additional PP submits that from the narration in the FIR, it is revealed that the petitioner at the time of the alleged incident was also carrying a blue color carry bag, and both his body and bag was searched, and the recovery of the contraband was from the blue color bag. Full stop. The matter, the hearing remains inconclusive. Full stop. List on 26, right? 26.
If time permits, we'll do it.
We may get time also. Let's fix it. Take a chance.
I'm obliged.
Is that judgment Pawan Kumar? Pawan
Yes,
Kumar?
State of Himachal Pradesh
50,
versus
on
Pawan
50,
Kumar.
on
Yes.
50, no? See it again. No representation. After some. Charlie, please come.
May please, Lord. This is my lord, charge sheeted case, my lord. Yeah, my lord, the FIR, my lord, case 14, two persons were, my lord, they are coming from Tinshukia, my lord. And they were apprehended in Lamding, my lord. From two persons, my lord, 24 kg was ganja was recovered, case 22, my lord.
Page 22.
Case 22.
Hmm.
Page 22 is the forwarding. FIR, my lord, page 16.
Yes.
This is to inform you that today on so-and-so, I have received an information at so-and-so from secret source that two unknown male persons are carrying illegally some narcotic contrabands on general codes of train number so-and-so, so-and-so. Accordingly, after receiving the information at around so-and-so, I, along with the staff of Lamding so-and-so, in and independent witnesses, have been left for conduct a checking on the general codes of the said train, along with taking electronic weight machine, etc. And after arriving the said train, we conducted a checking on general course of the said train, Lamding railway station, and during our checking, we noticed two persons are sitting in suspicious manner of general course of the said train. Therefore, on suspicion, we detained them and deboarded them along with two numbers of bag, one trolley bag and one P2 bag at so-and-so near foot overbridge, and asked them to open their bag to show content of their bags. Accordingly, they opened their bag in presence of independent witnesses and recovered 3 numbers of packets wrapped with brown color plastic tape suspected to be ganja, having total weight 12 kg approximate inside the gray color trolley bag, and 3 numbers of packet wrapped with brown color plastic suspected to be ganja, having weight 12 kg inside the P2 bag from the concierge possession of so-and-so Mohan. So-and-so is the petitioner here, my lord, and another person, my lord, is Karnumal Sarkar. The total weight of recovered total 6 number of packet 24 kg, and I interrogated them, and on interrogation they have been admitted their guilt before the police, and they stated that the said recovered suspected ganja were brought by them from Agartala to for carrying towards Tinshukia for illegally selling purpose. Therefore, the recovered articles were seized by me in presence of available witnesses at Lamding police station, number so-and-so, at near foot overbridge by observing all formalities as per law. And after observing all formalities, we brought the detained person, 2 persons along with seized articles suspected ganja, alarming so-and-so for taking necessary action. It is also mentioned that I have issued notice under section 50 of NDPS Act to them, and after acknowledgement by them, we searched their body and recovered one so-and-so, so-and-so. And on the basis of this, my lord, FIR has been registered. Case has been registered, my lord, and 20B to C29. C, my lord, from 2 individuals, my lord, separate bags, they carrying individual bag, my lord,
Okay, but they segregated.
lordship. And
So and so
they
inside
were arrested, my lord, without furnishing, my lord, arrest memo, my lord, and
total
complaint 36, my lord.
24 kgs. That's all. Since the total kg weight was
24
24 kg.
From
For
two
sections
lost.
C has been given.
24 kg.
As, my lord, total 24 from 2%, my lord.
Seizure list, my lord, page 21.
Seizure it also says
20.
24 kg from 2 bags, from 2%. Individual,
Seizure list 21, page 21.
Individual quantities, can it be seen separately? Then
Lost it.
maybe
Well,
they'll-
one seizure list, my lord, both were
one scissor list.
seizure list, my lord.
Then might be difficult.
seizure list, they have made one seizure list, but contraband was seized from 2 persons.
I Bhupen Kolita Swanson sees the following suspected member on the position, namely Mohan Namasudra and Ornamoni Sarkar. One trolley bag containing 3 numbers of packets. One P2 bag gray color containing 3 numbers of packets. They have not indicated, it seems, which bag.
2 bags,
One
each
trolley
bag
bag, my lord.
contain, my lord,
Mm.
3
Two
numbers.
bags. 2 bags carried by
bags,
2 persons.
And
And each bag carried 12.
yes, my lord.
So if
They
it
were
is, say, this bag 12, this bag from this person, this bag from this person, then maybe, in that case, commercial quantity section may not come
Otherwise, here,
But-
my lord, both were traveling together.
together. Is the
Together,
thing.
train ticket.
They have not indicated which form,
And
where.
one seizure list, my lord.
The bags were with them together.
Yes.
That is why they have given like this.
And second issue, my lord, 36 notice has been not given, my lord, and 48 also not furnished.
48 not furnished.
48
That,
also not
that,
furnished.
that can help you.
Lord.
Otherwise, we have to see the merits, if the Caesar witnesses are supporting, then 37 becomes very difficult to pass. So let us see
No.
if 48 is not complied, then
36 and 48, my lord.
48 is very clear,
Lordship.
right? So
And your lordship has also discussed 36 in so many cases, my lord.
36, of course, because of the nature of the
Lordship.
offenses,
Yes.
they even if they don't give notice,
I will, may I go?
what is the deficiency in 36? Notice was not given.
No,
Notice, though, in this cases,
arrest memo was not
May
given and
not-
48 notice not served, my lord.
that will be fact.
Then, my lord, I may go for the report.
Have a look. It's tagged also. It will give-
Yes.
48 can save you maybe, otherwise on merits. It's always difficult. Once charge sheet is submitted, very difficult, 37. This ground was not taken earlier, no? 47. 47 is there, but
47 is there.
48 is not
No.
there. Please sit down and
Lord.
part dictate. You go through the record, I'll dictate in part. Heard Mr. R. Learned Counsel for the. You say, have a seat.
Lost.
Ms. V. Bhattakur learned additional PP first. Invoking 483 BNSS, the petitioners herein are the petitioner herein, namely Mohan Namsud, seeking regular bail in connection with special NDPS case number 34 of 25 under section so and so. Within bracket arising out of Lamding GRPS 13 of 25. Case is stated to be pending before the learned special judge Hojat. The petitioner along with co-accused were arrested on 29/4/2025. The gist of the allegations in the FIR was that on 29/4/2025, information was received about carrying of contraband in the by persons in Kanchenjunga Express, Kanchenjunga Express. Accordingly, a team of GRPS proceeded and deboarded the present petitioner and the co-accused. And the two bags that they were carrying were searched, and suspected ganja of 12 kg was found from each of the bags, totaling 24 kgs. They were arrested. They were arrested and subsequently forwarded for remand. Mr. Ali, learned counsel, submits that. So the total quantity is stated to be 24 kgs, but from each bag, 12 kgs of suspected ganja were allegedly seized. And looking at it from that point of view, the individual quantity would perhaps fall in the bracket of intermediate quantity. Full stop. He also submits that no notice under section 36 of BNS was provided.
36 is there. Applied.
Also, as per his instruction, full stop. It is also submitted that notice under section 48 BNSS, which is required to be given to the family member of the arrestee, has not been so given, and therefore such non-compliance would vitiate his arrest. The case what is the stage of the case?
Fixed for evidence, my lord.
Trial is started.
Lord.
Charges have been framed already. It is submitted that charges have been framed and case is at the stage of trial. Stage of trial and prosecution evidence is going on. The scan record is available. The learned additional PP, yes, submits that the notice under section 36 is available in the record. And 48 is not there.
Regarding 48, one note in the forwarding notice report is there, madam. Notice under section 47 BNSS.
That is.
And WT message sent to guardian as per notice under section 48 BNSS. WT message sent.
It is submitted by the learned additional PP that though while notice under section 47 BNSS is available, as is also fairly submitted by the learned counsel, Mr. Ali, the notice under section 48 is not found in the record, though there's copy of WT message sent by the IO for furnishing of the notice under 48 BNSS to the family member. So now only the WT message or the
WT message, no, that is informing the forwarding report. Notice there.
Notice was sent.
Yes, notice was sent. Regarding that WT.
You have to take instruction then.
Yes.
Because if 48 is not there, he has to be given bail. Very
In
clear.
this point regarding WT message also, my lord, your lordship has already granted.
That's true, but just let's see. Only WT message may not help.
In paragraph 12, my lord.
That he has been arrested. That information may not help. That's not grounds.
Yes.
But if it is electronically transmitted and to be delivered, and it is delivered,
Paragraph 12, my lord.
then it's okay. Then it can be.
That WT
Paragraph
12, my lord.
there has to be material that was conveyed.
Well, a copy of that WT message is not available in the record.
So it is.
How do you know that?
Only from the forwarding report.
Forwarding.
Forwarding report.
Then it will copy no. From the forwarding to cut it out. Learned additional PP submits that from the forwarding. It is revealed that a WT message regarding notice under 48 BNSS was sent to the family member of the accused, but further submits that the WT message itself is not available in the record. So can we take a view that 48 was not compliant? Perhaps, perhaps. Full stop. The learned counsel for the petitioner has referred to a decision, an order dated 28/10/2025, passed by this court in BA 3158 of 2025, and draws attention to para 12, where it is stated as follows. In that case, this court was pleased to grant bail to the accused for non-compliance with the notice under 48 BNSS post.
That is, their notice there, forwarding, in the forwarding report,
Yes, yes.
notice. And arrest memo is also already flag mark.
No, that is okay. Arrest memo is there. Instruction is not correct. It is in the grounds of arrest. Forwarding.
Forwarding. Below, my lord, note of the IO is there regarding WT message regarding 48.
The scan record has been placed before me, and upon peruse and attention drawn by the prosecution to the forwarding report, in which it is stated that dash WT message sent to guardian as per notice under 48 BNSS. And accused challan are duly enclosed with the forwarding report post. Like in the next paragraph. Upon perusing the materials, I find that like in the, so I think 48 notice,
Yes.
like in the order of this court relied upon by the petitioner side, there are no materials, there are no materials to indicate that there has been compliance with the notice under section 48 BNSS as is required in terms of the constitutional mandate within bracket Article 22(1) Constitution of India and the laws laid down in this regard by Honorable Supreme Court. Within bracket reference Vihan Kumar, Mihir Rajesh Shah, Pravir Prakash. In the circumstances, this court is constrained to come to the opinion that there is no proper compliance with the notice under 48 BNSS as is required in terms of the afforded legal position. Full stop. Such being the situation, despite the penal provisions pertaining to commercial quantity, the accused is required to be granted bail as his arrest was vitiated due to such non-compliance and thereby violation of constitutional provisions under Article 22/21. Accordingly, 1 lakh.
What?
1 lakh with one surety of the like amount to the satisfaction of the
Special judge.
special judge Hussain, subject to the conditions. We don't know conditions to go about condition. This also conditions is wrong. He shall be available for the remaining fare, shall not hamper or temper activities, shall not indulge in any illegal activities, including any activities prohibited by the NDPS Act. Bail petition stands allowed in this post.
Public.
For 16.
May I please the motion? Lordship, the petitioner was arrested on 21/6/2025 charge sheeted matter NDPS case. They are booked under section 21C and 29 of the NDPS Act, Lordship. My case is of total non-compliance of section 48 of the BNSS, Lordship. Total non-compliance, and considering which the coordinate bench has already granted bail to one of the prime accused who was found on the spot itself and who was in fact the owner of the LSC's vehicle in question. Lordship may find it in page
Could
number.
it be placed before appropriate bench?
My lord.
But their time constraint is there,
My
only,
lord, my lord.
only 2 days are
My
left.
lord.
Only 2 days. Would you like it to be placed before appropriate bench? If the learned judge is available, if he's available.
If
Or if
Lordship, if it is listed before vacation, Lordship, of course.
Hmm?
If it is listed before.
Before?
Vacation.
If it is listed before.
My lord,
vacation.
appropriate
That is true.
My lord.
Is he available? I am not sure actually. I don't know.
Lord.
Because we don't meet each other.
Answer.
So busy. Yes. Otherwise, okay, I can also take.
Yes, Lordship, because
time
there is total non-compliance of 48 section, Lordship, in page number 39 of my petition, Lordship. Point number 19. It is
My
apparent-
humble submission is that already that court has already come for the report also, my lord. And
Correct.
co-accused already passed the order against
That's
the
true.
co-accused, my lord.
Mhm.
Here,
No, if I suppose disagree, then of course it should be placed
then,
before that
my lord,
bench.
then I will have
But
to.
if I agree, then I can also.
Then I will have to go to the record also, my lord.
Also.
TCR is there, Lordship.
My lord, I have also, my lord, here
And that's why I asked.
on the condition, my lord.
Is he available? Is he available in the principal seat? No.
No,
Not
not
available.
right.
Mrs. Kolda is available. Then to him.
Yes, in the principal seat, he is there.
Oh, he's there.
If
Oh,
not-
that's why I'm asking. Is he available in the principal seat? He's available. What do you say? Tomorrow before the appropriate bench?
If your Lordship is satisfied with my submission, Lordship may please.
So,
go
my lord,
through-
here also time consuming, I will have to go to record also, my lord.
Lordship, it is
Here-
very much apparent from the order sheet as well as from the TCR itself. Lordship.
No, I will have to go to the record
Yes,
also.
Lordship, if Lordship may fix it at 2 or.
No, today not possible.
Second half.
Several matters are here, my lord. Several scan copies are here, my lord. We will have to go each and every case, my lord.
Lordship, the violation is apparent. And
Anyway, so I think it should not be a problem tomorrow.
violation is apparent, Lordship, and already the co-accused has been granted bail in the month of
Definitely
February.
not that case, my lord. Priority is not applicable in each and every.
El Boni,
case, my lord,
learned
and
counsel
this
for
case, my
the
lord.
petitioner.
Their rules are defined.
Full stop. The scan record is available. First up, learned counsel submits that the primary contention in the bail petition is total non-compliance with the notice under section 48 BNSS. Full stop. And on the safe ground, coordinate bench, this court was pleased to grant bail to the co-accused against whom there were more serious allegations. Full stop. In the context of the same, the learned additional PP submits that he has to go through the record, and in any case, perhaps this court may consider directing the matter to be placed before the appropriate bench. First, I have given my consideration to the submissions. First, list the matter before the appropriate bench tomorrow. That is 25/6. 25. If necessary, you make a mention to be taken up at 2 o'clock for that bench, right? Should not be a problem. Don't worry. Come in supply list.
May I please, Lord? My lord, case diary was called for here in this case, my lord.
Did you receive my?
I have taken steps upon the response number 2, my lord.
Boxer matter.
My lord. My lord, I am behind the bar since 45 days, my lord. FIR is at page number 9.
You are appearing for informant?
My lord.
No, he's appearing for informant.
Yes, he is appearing for information.
Oh,
No,
and we have to check the status of the notice then.
my lord.
Service report is awaited.
Service report, my lord.
Can you take the instruction? Since
service
vacation is
report not
approaching.
received, my-
My lord, finally day after tomorrow.
Yeah,
Service report not received.
Please take the instruction.
Day after
Full stop.
tomorrow.
The CD is received. Case diary is received, however, the service upon
That's phone number 2, Mali.
no, that's true, but the postal tracking, you're taken by speed post.
Mali.
Speed post, postal tracking has been there, it's available.
They will have to take the steps for office, if they have not taken step for office, then it would be difficult.
On last occasion, it was directed to take to registered post. Earlier occasion, I have took a step through registry, Mali. Last occasion. Anyway, Mali, day after tomorrow, kindly take a.
But as part of the survey, full stop. Earlier, there's a office note dated 12/6, which says that the postal tracking is flagged at placed at flag A, and it shows delivery.
My lord.
But again, have you taken steps twice?
My lord, I have taken twice.
Oh, so
On last occasion also.
second time you took through the office
My
of the
lord.
public
My
prosecutor
lord.
also. First time he took through, that will not do. Postal tracking will not do.
Postal
You
tracking,
can
but as per the decision of the
appoint
division bench,
huh?
as per the order of the division bench, they will have to take a step through the registry.
Okay, that's
Yes.
Deepak Naik, that's
Yeah,
so that's also
If
stipulated.
earlier also they
Earlier
have
also I
taken
took
steps,
steps
then
from
I
this-
get the instruction, if there is earlier.
Last
also
time I
they-
took through registry.
No, so
Second-
that is mentioned in Deepak Naik, that steps are forgotten. Steps also have to be
Yes,
taken
they
through.
will have to take service through registry, registry will supply it to the office of the public.
Oh, so
prosecutor.
like that. Mode of
Then-
that.
Then I will raise. office
I
of the
stand
public
corrected. So,
communicate it.
full stop. Full stop. It is submitted by Mr. Pramanik that steps were taken to the office of the public prosecutor and to be executed to the concerned police station. Full stop. As per office note dated 22/6/26, service report is awaited. The prosecution shall take instructions regarding such service.
Yes.
Okay.
Yes.
26,
Mal.
last day.
Alia.
Yes.
I sincerely apologize to interfere in between,
No,
Lordship.
yes.
My matter has been heard already. Lordship, it has been ordered to be listed before the
Tomorrow,
applicants. However, Lordship, I have just gone through the cause list and Justice Anjanmani Kalita is not there in the principal seat right now.
Oh, he's not there.
He's not there.
Yes.
Then do one thing then, ordered, okay, no problem.
Then also fix day after tomorrow. In the meantime, he will have to go through the scan.
No, I'll modify it. Date will work it out. It is, however, this by a coordinate bench will stop. The learned counsel, however, submits that at present, the said learned judge is not available in the principal seat. Good stop. Given my consideration, as the learned additional PP is seeking some time to go through the record, therefore list the matter. Should be tomorrow?
Tomorrow also.
Day after tomorrow. Okay, day after tomorrow. Day after tomorrow. We'll hear all the matters on day after tomorrow, but you have to stay at night, ready to be stay at night. All of us, after taking some breaks.
My pleasure, Lordship. Lordship, I have been instructed to withdraw this petition, Lordship.
Remove application code to redeem. Last two, sir. The Mr. Learned counsel for the Mr. Chutia learned counsel for the petitioner submits that he has instructions to seek withdrawal of this bail petition. The prayer is allowed. The bail petition is disposed of upon withdrawal.
May I please also. Also, FIR is the please 9, my lord. The 5.090 kg of ganja was seized, my lord, from the premises of my lord, the petitioner number 1. I'm reading to you, madam. I so submitted on 16/5/2026 at about 11:15 p.m. Reliable information was received from credible sources that a huge quantity of ganja has been illegally stored in the house of villager at Nalbari village under the jurisdiction of Rota police station for the purpose of sale. Accordingly, the matter was entered in the GD and I informed the Deputy SP headquarters, Madam Udalguri and CI Rota. Thereafter, the CI Rota directed me over phone to collect the authorization letter under section 41(2) of the Narcotic Drugs and Psychotropic Substance Act 85, from which officer for conducting the necessary search and taking legal action accordingly. Accordingly, I, along with SI Pranab Kumar Deka, SI Raj Kumar Tahir, UBC Bhavan Kusumatari, and UBC Swang Boro, Rahul De, and left for the spot carrying the official digital weighing machine for necessary action. After obtaining the authorization letter under section 41 of the NDPS Act from the office of CI Rota, we proceed towards the suspected area. While waiting at Nalbari Chowk at about 11:40 p.m. further information was received that one person from Uttar Pradesh had arrived at the house of Mangal Boro. Well, Mangal Boro is the petitioner number 1, resident of Daifang Uti PS Rota, for making a huge consignment deal for purchase of ganja. Accordingly, we immediately proceeded to the house of the said person and conducted a house search in presence of independent witness. During the search, one person was found inside the house, and on interrogation, he identified himself as Brijesh Jadhav, date of birth 1/1/2003, resident of so-and-so. He voluntarily stated that he had come to the house of Mangal Boro for making a consignment deal of ganja. During further interrogation, he stated that Mangal Boro had already shown him a sample of ganja, which had been kept inside a bamboo paddy storage basket in the house. Accordingly, Mangal Boro was apprehended from his house, and during the search of the bamboo paddy storage basket, one white color plastic packet containing suspected ganja weighing 5.090 kg of, including the plastic packet, was recovered and seized as per law in presence of the witness. So this is the firearms. And so far, my lord, notices are concerned, my lord. This petitioner number 2, Brijesh Kumar, 48, has not been complied with, my lord. And so far, the petitioner number 1, that the notices were complied with, my lord.
48.
48 has not been complied with in case of petitioner number 2, my lord, Brijesh Yadav, my lord. 47 has
He's
been
from outside.
my lord. He is from outside, my lord.
When they were
Just
16/5. 16/5.
Today is 40 days, man.
Well, for days, 40 days.
40 days.
40 days.
Kindly see the compliance aspect first.
Yes, madam. Regarding Mongol Guru, my lord, 47, 48. There, my lord. And regarding, my lord,
Brijesh Yadav. Brijesh Yadav.
Brijesh Jadhav is from UP, my lord. From the residence of Mongol Guru, that, my lord, ganja, more than 5 kg was recovered.
Intermittent one.
Police will have to work out this protocol when person is from outside, how exactly they will go about it. Their nitty-gritties also fall in police administration, not just law. Anyway. It has to be taken from him and then sent. Okay.
Yes. Well, my lord, he is from Uttar Pradesh. So, my lord, no note is there in the forwarding report, my lord, regarding sending the same. So, by any.
No.
There's no compliance, it seems.
Yes.
Otherwise, what are the materials?
Materials, my lord, those from the residents of the Mongol on the basis of the specific information that one person from UP.
These are witnesses of support.
Yes,
They have support.
yes, my lord. And Caesar witnesses, my lord.
FSL is not arrived, no? FSL is not awaited.
Yes, my lord. One note is there, my lord, regarding only one note that to the, my lord, SP, additional SP Udalguri, my lord, why? That's NDPS said he will be produced before the CJM Udalguri next day. You are requested to kindly inform his family members regarding his arrest. That is not sufficient. And 47 complied with. 48.
Heard Mr. Vijay Saikya, learned counsel for the petitioner, and P. Bhattakur, learned additional people. Under section 483 BNSS, the two petitioners, accused petitioners, are seeking regular bail in connection with Rota PS case number 29 of 26 under so and so section. They were arrested on 16/5/2026. The FIR was lodged with the allegation that an information was received about peddling of narcotic drugs, whereupon they went to the house of petitioner number 1, and there the petitioner number 2 was found, and it was revealed from him that he had come there for a consignment deal of ganza. Subsequently, the house premises were searched, and intermediate quantity of suspected ganza, being 5.090 kgs, were recovered. Were recovered and seized in the presence of witnesses. Mr. Saikya, learned counsel, submits that with regard to petitioner number 2, who hails from outside the state, there has been no compliance with section 48 BNSS regarding furnishing grounds of arrest to the family member or nominated person. The learned additional PP submits that investigation has revealed incriminating materials, and that the seizure witnesses have supported the seizure of the contraband. It is fairly submitted by the learned additional PP that, except for a WT message to Udalguri police, right? Udalguri police.
No, my lord, it is UP, my lord, from the to the Azamgarh, my lord.
Azamgarh police. Azamgarh police. To inform family members of petitioner number 2. There is no other materials regarding proper compliance with section 48 BNSS. As I said, these have to be worked out by police.
Yes.
Because the police may not have phone number of, within Assam they will have phone number of police station. They can quickly get it. But they are not likely to have phone numbers of each police station in the country.
Yes.
So what will they do in that case? How will they execute? They have to work out the protocol,
Yes.
SOP, and full stop. So he has to be granted bail on technical grounds. But what about the other person?
Regarding Mongol Borough, my lord, only on the ground of length of detention. Otherwise, my lord, everything was complied with, my lord. Intermediate quantity, 40 days. Materials is there, my lord.
Stop. Thus, I find that with regard to petitioner number 2, there is non-compliance with section 48 BNSS in the manner required by the constitutional provision and the case law and the laws laid down by the Honorable Supreme Court in this regard, and therefore his arrest being vitiated, he is required to be granted bail at this stage. Therefore, it is directed that the petitioner number 2 so and so is hereby allowed to go. The bigger risk is regard to him actually. Is allowed to go on bail of rupees 50,000 with 2 sureties of the like amount, one of which has to be from the state of Assam, and subject to the satisfaction of the which court, learned trial court, Udalguri, learned court below, and subject to the conditions that he shall cooperate with remaining investigation and shall not abscond and shall not hamper or tamper with it. However, with regard to the other co-accused, considering the materials and the nature of the alleged offences and the fact that investigation is still ongoing, the bail petition stands rejected as regards him at this stage.
Well, sorry to intervene, my lord. Your lordship has rightly pointed out, because in other cases also, my lord, considering the length of it, otherwise, because he is from, my lord, UP. WT message sent through, my lord, to the Udamgarh police station. Azamgarh police. So in this type of cases, my lord, where he is from outside the state, my lord. So if technical ground, my lord, otherwise how police has to send through the WT message, my lord, regarding that some dark area is there, my lord, regarding.
Best is if he gives a nominated person. No, if he gives a nominated person. Suppose he say from just
regarding that note,
practical. Suppose he gives a nominated person, this one, his number, and you WhatsApp the 48 notice. That's all. What else can you do? Because that will take time.
Yes,
they will go.
Both may be.
Because they may not have the phone number of Azamgarh police station. They may not have. They will get it. They can get it. Police is all interconnected, but it will take a little while. Immediately may not be possible.
Yes.
It will take some time. So
These things consider the other petitioner, my lord, considering the length of distance.
it was very serious, drugs, because he was the person who was allegedly peddling from his home. Right? So he can get statutory bail in the meantime. 2 minutes.
POCSO case. On the last occasion, TCR was called for. Lordship, I have checked the office note. Perhaps the notice has not been served to the respondent number 2. It is showing up on Talabana, but same has not been reflected in the office note. Lordship, the registry may be asked to inquire into this matter. And
registry?
Yeah, and Lordship may fix it after vacation. 17th July, possible. Lordship.
You're Mr.
A. Tarafdar, appearing on behalf of S. Nawaz.
Okay. Learned counsel for the petitioner who submits that perhaps the registry may be requested to look into the aspect of service upon respondent number 2 and put up a suitable updated office note.
Lordship, TCR has been received, I have checked.
Scan TCR is available.
My lord.
It is submitted that steps have already been taken upon the said private respondent. The registry shall do the needful regarding completion of service. They will check up and update the office note if any. List them at the Learned Counsel place for posting the matter after the break on 17 July. List on 17. 17/7.
May it please your lordship, my lord.
Mr.
Regular
Devas.
bail application, your lordship arrested on lordship 2/4/2026 as on till 51 days, your lordship. So FIR is at phase 13, your lordship. So it's a case of suicidal death, by hanging of a minor girl, 17 years.
21.
21. 17 years, 4 months, your lordship.
Yes.
So allegation in a nutshell against me, your lordship, that I developed some physical relation with the.
My lord, here POCSO 6 is also there, my lord.
Also is there because of your
My
lordship,
lordship,
there's shortage of your
notice,
lordship.
my lord. Notice, my lord. CD also notice it today, my lord.
But your lordship, 51 days, your lordship, earlier.
It is a 90 days offense, my lord. There is
90
POCSO
days is
notice
there,
is
but-
also required,
but
my lord.
But there is a long vacation, your lordship. So my submission, my response submission is that your lordship, Also, the allegation is there that I have developed some physical relation with the victim girl, Your Lordship. But the case is otherwise, Your Lordship. The hospital authority, Your Lordship, informed the police, Your Lordship, that a girl of 17 or 4 months committed suicide, Your Lordship. Accordingly, police came, Your Lordship, found him dead by hanging, Your Lordship. And thereafter, mobile phone was recovered from his possession, Your Lordship. Only allegation against me, Your Lordship, that in the mobile phone, 2 tablets of abortion, Your Lordship, was found, Your Lordship. But, Your Lordship, I have annexed one document, Your Lordship, that is at page 23. Actually, this particular girl, Your Lordship, she developed love affairs with another boy, Your Lordship. So, Your Lordship, I am the relative, I am the maternal uncle of the victim girl, Your Lordship. So, Your Lordship, had there been any such type of allegation, certainly there would have been FIR from the side of the parents, Your Lordship. There's no such FIR. So, police, because of the fact that the mobile phone has been recovered from my possession, 2 tablets were found inside the mobile, Your Lordship, that the victim girl, Your Lordship, eventually
My lord, here Lordship may earlier also city was called for, my lord, and notice was issued, my lord. Today I have not received the case there, my
The
lord.
case diary will be necessary.
My lord, my lord.
You must have taken steps upon the respondent, right? Upon
Yes,
respondent. You, at best, we can, if he insists, then we can take it on Friday. But
No.
you have to take instructions and seek the case diary again. Otherwise, after
My
vacation.
lord, after vacation, reopening, my lord.
51 days, Your Lordship, as on date.
My lord,
So actually my submission is that, Your Lordship, allegation part against me is that I have developed love affairs.
That's true, but without CD and
My
without
lord.
notice, you can take instructions. You take the
Instructions.
instructions.
Just reopening, my lord.
But they can take instruction, Your Lordship, within day or two, Your Lordship, because the long vacation is there. I'm
No, my
51
lord,
days behind
vacation
the-
is the
But
consideration,
Your
my lord. Here,
Lordship,
Lordship may kindly
the-
pay ground of arrest, my
The
lord.
ground
Page
of
17,
arrest
my
is
lord.
there, Your Lordship, but
Page
from
17, my lord.
ground of arrest is, I'm not denying the fact that.
CD is
No.
required, my lord, here.
It's required.
My lord.
But the thing is that
One minor girl died, my lord.
No,
Here is
CD
the
is
allegation
required.
of exploitation,
No.
my lord.
Serious matter.
minor
Divan
girl
cannot
died by hanging, Your
That
Lordship.
is
We
required,
cannot
my lord.
give
There is
bail
also is
But
there.
you
without
Lordship,
seeing the
there's-
CD, without notice.
Fine.
How can I?
Fine.
The case diary is not received, full stop.
That's correct, Your Lordship, but
Just
there
reopening, my lord.
But
We'll
there
put
is-
it against them.
there's no FIR from the
I
side.
can
of the
fix it
parents.
on, I can fix
There is no FIR from the side of the parents, Your Lordship. This is here. If the allegation is true, this is heinous.
It will be revealed
But-
from the
but
CD, my lord.
certainly-
All the
certainly
everything will be
FIR
clear, my lord.
FIR must have been lost from the parents, Your Lordship. Only because receiving
Because
the
they have found
information.
some materials that
My lord.
he had repeated, with a minor.
My lord.
Relationship with a minor, which whatever you say, I know, if it's true, then it amounts to the
My lord.
POCSO Act. So, but the death aspect, of course, what
Already-
happened,
Already they have taken considerable time, Your Lordship.
14th, my lord. 14th.
Considerable time already been taken, Your Lordship. So if I am, Your Lordship, there is acquisition is that would prove in the trial, Your Lordship. But at this stage, custodial interrogation may not be necessary, Your Lordship.
Mr.
Already 51
Devan
days.
submits that steps have been taken upon the respondent number 2. Its service report is awaited. The learned additional PP said take instructions regarding service upon respondent number 2 informed full stop. The case diary is also not received, full stop. Learned counsel, Mr. Devan submits that despite the nature of the allegations, there is no FIR has been lost from the side of the parents of the deceased girl. Full stop. Full stop. Nevertheless, I find force in the contention of the learned additional PP that perusal of the case diary is necessary, and therefore issue press requisition for the case diary. From which police station? This
My
one?
lord. Abhayapuri, my lord.
Abhayapuri.
Made on Friday, Your Lordship.
No, no.
Abhayapuri PS case number 69 of 2026. At best, we can fix it on
14th, fine.
if he insists in the vacation for 2nd July. At best, 26 I can fix, but will it come? We can fix. Fixing is not a problem, but will it come? That's the thing.
That is the.
Instruction also you may be able to.
My lord, it is
You may be able to take.
whether on which day they have taken steps, my lord, whether it was
Mhm.
to our office or not, my lord, then we'll have to take instruction. If it is Talabana receive on our office, my lord, then we can take instruction.
Okay, fix one to 2nd July.
2nd of July. Your Lordship.
July vacation court. You will not be there. You may not be there.
Lordship.
So either on 26th on reopening or reopening.
14, 26, they may try, Lordship.
No, no, my lord, day after tomorrow, my lord, how it is possible?
13th,
13th, my lord.
13.
13th, sir.
Right.
1 day hardly makes it.
Leave it there.
আজি কেনে যাব? 22 পৰহি কেনেকে চিটি আনিব আৰু?
May please your lordship.
Yes, madam.
This is such case, my lord. FIR is page 9. The lady is it about 24 years old now?
ITI. FI, 1 minute.
FIR
Diary has come.
No, my lord, scan
can
copy of
copy was called for
Last sheet.
last occasion, my lord.
FIR, I'm on the FIR, madam.
Yes.
It's okay, see the major, they entered
Major,
into
my
our
lord.
relationship.
She
But the
refused.
problematic part is this.
Yes.
Filing.
Later on, my lord.
But no, my lord, she refused the medical examination also, that is phase 18. And he was arrested on 10/3/2026.
10-3.
2026. 10 March.
Can we see from the materials,
My
those electronic materials have been taken down from the internet?
My lord,
Hmm?
yeah, in that
Yep.
scan copy there is, my lord. And here, my lord, charge was framed on 7/5/2026, my lord,
Uh-huh.
under section 69, 351, subsection 3, and 67
ITF.
A, my lord, ITF. And my lord, 16/6/2026, my lord, 3 PWs were present, my lord,
Mhm.
but they have took time on that day, my lord. Then the,
Has she been examined?
my lord, not yet examined,
Not yet.
this is, my lord. Here, my
As I said, no, the other things we can partly overlook. Those 2 adults,
my lord,
but viral link is a very serious matter. Madam will also agree.
my lord, my humble submission is that at least 15 may be examined, my lord.
That's why I asked, have they been taken down? Those, any photographs of hers or?
Photographs, some of the photographs here.
IO must take them down from the internet with the help of their
Yeah,
cyber cell.
Photographs are there.
No, I don't know. They've been taken down
Fine.
from the internet.
In that,
Yes,
fine.
sir.
So that the person is protected,
My lord,
the victim is protected. They must be taken
my
down
lord, my lord.
from the internet. Any materials to indicate that the police has removed those materials from the internet?
No, there are not any.
They must have had a relationship, but the thing is that why they do these things? Have a relationship, another matter. Viral link is
Thereafter,
Both are adult, my lord, and she came to his house, my lord.
the woman can be
By
extremely
herself.
vulnerable in this kind of because she may be subjected to blackmail. Then
blackmailing them.
no,
Yes.
that is the worry. That's the only worry. Otherwise, so she should be examined.
My lord, at least my lord, 15 may be examined, my lord. Otherwise, there is a part of cheating or hampering, tampering. my lord.
Lordship, period of detention, lordship can
that
grant
is
bail,
there.
my lord. Yes, my lord.
Anyway,
He also moved in the law session code also, but it was rejected. That is page 22.
heard they will learn counsel for the petitioner. Full stop. Who invoking 483 BNS seeking regular bail in connection with Gologon's PS case number 59 of 26. Post up under so and so section. He was arrested on 10/3/2023. The FIR was lodged on 7/3/2026 by the alleged victim woman herself, indicating her age as 23 years. It is alleged in the FIR that she developed a romantic relationship with the petitioner, followed by some physical relationship, and that the petitioner gave her false assurances of marriage. It is also alleged that the family members subjected her to physical and mental cruelty, and unable to bear the same, she returned to her home. The informant is given particulars of uploading of her private photos and videos on social media by the petitioner, and that he has been pressurizing her for physical relationships over this. The case is at the stage of trial. The scan record has been received. The learned additional PP, Mr. Summer, submits that the victim woman has not yet been examined. Considering the aspect of the allegations pertaining to uploading of the personal photographs of the victim on the internet, and the fact that her evidences were not yet recorded, the bail petition stands rejected at this stage. The IO of the case is also directed to engage with the cybercrime authorities of police and do the needful so that the photographs, if any, the photographs or videos of the alleged victim are taken down from the internet, if not done so already. A copy of this bail order shall be sent to the concerned IO. For this purpose, a copy of this order shall be furnished to the learned additional PE. Only this aspect. Otherwise, it was a case of bail.
Obliged.
Disposal.
23.
Wait, please, your lordship. My lord, page 9 is the FIR, my lord. On the offense, my lord, my lord, is 12 of POCSO, my lord. Our maximum punishment, my lordship knows is 3 years, my lord.
Lordship, we have filed a written objection in this.
Just a minute, no? Just a minute. I'll come to you, don't worry. So. POCSO arrested on 19/5. Sure. Just give me one.
Lordship.
All right. Yes. You are appearing for the informant.
Yes,
And
Lordship.
you have filed an objection.
Yes, Lordship.
Okay, already filed.
Already filed on 22, Lordship.
Okay.
That was not filed, Lordship.
No, my lord,
That is
I
not-
have got a copy.
As per his submission, that is not part of the record.
It seems so. Could have mentioned in the morning anyway. So let the objection come. You can take it up today. We have some constraints. Again, second half I'm sitting. I'll be here. So tomorrow? Tomorrow or day
I'm not
after?
available, Lordship.
Day after tomorrow. Full stop. Mr. Abdullah, Learned Counsel, and your good name, please?
MS Mondal.
MS Mondal, full stop. Learned Counsel appearing for the informant who submits that written objection has been filed. But the same doesn't appear to have come into the case record for the court. The objection may be brought into the case record. Full stop. The Learned Counsel for the petitioner, however, has received a copy of the same. Case diary is received and shall be retained till the next day. List on 26.
Obliged, my lord. Actually, my lord, they cannot file objection, my lord. They can only assist the PP, my lord.
That's
Written
true.
objection, my lord. Yes, but the practice, my lord, I am not objecting to it, but it's obliged, my lord.
Victimology. Actually, written objection through the public prosecutor. Right?
Yes. Otherwise, when the practice is that.
Do they file through public prosecutor?
No,
or
they
independent.
directly file.
Actually, it should be through the public prosecutor, I think.
Well, the
I'm-
practice is going on that.
I may
everyone
be wrong
will
also,
do
but I
objection,
think
file objection.
conventional approach should be,
Yes.
or conservative approach should be through the public prosecutor.
Yes.
But these things are emerging.
Go to the-
More rights are being given to victim.
Yes.
It's better to file it through the public prosecutor always.
May I please allow? This is a
Yes.
FIR. The FIR has been lodged in 17/5/25. I was granted interim in
Yes.
30/5/25.
Mhm.
For the last 1 year, I did appear also. My name has
Yes,
not
yes.
been reflected in the FIR lodge.
Mm.
As per my instructions, search sheet submitted.
Some, against him also.
Yes.
He may not have been charged sheet.
Lodge.
Hmm.
I believe I am, but I also.
Only I have received instruction regarding filing of search sheet, my lord, specifically, my lord, whether search sheet filed against the present.
There was a clash between the two parties. I was just a bystander. That's why I was not named in the FIR.
Unfortunate bystander. Anyway, so let us, I'll dispose it of, making it absolute.
Lodge.
If it is not there, so
Lodge.
not sent up for trial.
Already in interim protection. is there.
And counsel for the petitioner. Who submits that, he was granted, the petitioner was granted interim earlier. And, and he has also, he was also not named in the FIR, full stop.
Lodge.
The learned additional PP submits that though case diary was called for, but it has been informed that investigation stands completed and has resulted in a charge sheet. In view of the completion of investigation, like that,
Lodge.
the interim bail granted to the petitioner. Right, so in order dated
30/05.
30/05/2025 is hereby made absent. Hereby made absolute, subject to the condition that he shall cooperate with the process of law. That's all. Deeply of disposed of.
25/26. 25/26 for case diary not received, man.
Let's see the petitioners are on interim.
Same order of, actually, the case diary is stated to be not received, full stop. Issue reminder for the same. Interim bill granted by order date. Interim was granted on the same day, right?
On the second day.
No, I'm saying both dates are same. Interim order dates are same
No.
in both the cases.
Different, Lord.
Oh, different. The bill is good. Interim order passed, right, order dated so and so. Date stands extended till the next date of listing. List on
28/7.
28/7. Order खाली interim order.
Obliged.
27.
Date to किमान लेते हैं? वो तो date to किमान? 28/7.
Your Lordship, on this,
Yes.
CD was called for. And CD has been received, Your Lordship. However, Your Lordship, there is one unusual grounds in this case, Your Lordship. Petitioner number 1, Your Lordship. Petitioner number 2 has received interim and he has appeared before the investigating officer. However, petitioner number 1 is confined in a jail in Kuwait, Your Lordship. He is in jail and he is serving a sentence for a check bounce case for 6 months, which is about to complete next month, Your Lordship. And he is under interim protection in this case, Your Lordship. Kindly, another date may be given before which he can appear before the investigating officer, Your Lordship. Petitioner number 2 has appeared already, Your Lordship.
My lord, here update CD is required, my lord, as he is in the my lord. In the earlier occasion also.
Are you on interim?
I am on interim, Your Lordship.
Both of them are interim, my lord. And again, my lord, regarding the petitioner number 2, if he is not appeared, my lord, let them appear again, once again, my lord.
1 has appeared, 2 has not appeared.
2 has appeared, 1 has not appeared, Your Lordship.
Mr. P. Laskar Land Council and Sharma Learned Additional PP. Full stop. It is, the learned additional PP submits that the updated case diary would be necessary. You have received, no? It's not updated.
Not updated.
The case diary is received but not updated.
My lord.
And that the updated case diary may be, the petitioner may, the prosecution may be given an opportunity to procure the up-to-date case diary. Full stop. Mr. Laskar, Learned Counsel submits that pursuant to grant of interim, petitioner number 2 has appeared, but petitioner number 1 has not been able to do so, and that him that he would appear for the IO shortly, right? Full stop. Now, the interim order stands by so and so stands extended till the next date of listing. Full stop. The case diary may be returned and procured again with the updated investigation list on
Any date in the last week of July, if possible.
28,
Fine.
like 28/7.
Deeply obliged.
28 and 29.
Please, your lordship. May it please your lordship, the accused Himanshu Bose. Your lordship, we have already submitted the so-called reply on 4th May. And the other accused, namely Josna Bose, is already in interim bail, your lordship.
This is for DRI.
Yeah. The charge sheet already been filed, your lordship.
Your lordship, the role of the, in item number 29, Himanshu Bose and the flag number
It's
9.
pertaining to what matter?
One is the
It's,
foreign secret and other one the
foreign
poppy
secret
secret.
and poppy seeds.
Huh?
Poppy seeds.
Okay. NDPS.
No, it doesn't
It's
come
a
under
opiate.
any.
It's a opiate, so it's actually illegal as per Government of India order, but doesn't come under NDPS.
It's not illegal, your lordship.
It is
Until the poppy seeds has been extracted to make some illegal products. Which is excluded from the poppy straw, which comes under NDPS Act.
Anyway, just
It's used for the edible food.
9,000 kgs, not a small amount,
9,000 kgs of poppy seeds.
around 3 trucks.
Let us see the FIR first.
FI is not
It is
annexed.
not only from one of the accused, it has been taken from some others, included all the accused.
Let me see this previous order, just a minute. She was given interim bail.
Yes. But
Correctly, so
in
she's stated to
29
be living separately also.
Yes.
Yes, Lordship.
And
Yes.
29, he has not been granted interim bail because he's the main person involved in this whole racket.
Hmm.
And his involvement, I have flag marked, your lordship, in flag number 7 and 8 of the proposal.
What are the provisions under which it has been seized? What is the law under which it has been seized?
Law as such, I have flag marked from this, it's a huge effect, your lordship.
Yeah, this
Flag mark 2, your
is
lordship.
there.
There is a so-called notice, this is akin to a charge sheet. Your lordship. Flag mark 2, your lordship.
No, this act of possessing such poppy seeds is a violation of which law?
There is a gazette notification. your
Gazette
lordship.
notification.
It's written in flag.
Your lordship, nothing has been recovered from the concise possession, your lordship.
Because he has been evading arrest. Now this is the AB
Then-
petition. your
Your
lordship.
lordship, they don't have the concrete evidence also. There's also been
No, evidence is there. In fact,
only the telephone numbers that
there.
they use. They have
everything is there in the show cause notice. That's why it has become such a huge bunch. Because
Well, n number
several
of people, your
increasing
lordship, n number of
documents
accused
have
are there.
been actually seized. Just that the petitioner is avoiding arrest.
Your lordship, he already appeared before the DRI office also. Your lordship, he's
Let him
replied a
appear,
so
your
notice.
lordship. Let him appear.
So he's compliant with all the accordance with the law, your lordship.
Make your submissions, I'll write it down, then I'll look into it.
Yes, your lordship.
Because I'm not so familiar with this, it seems.
Now, in fact, in terms of
It is the illegality is violation of the gazette notification,
gazette notification.
which makes it a penal offense.
penal offense and also illegal under the Customs Act.
And
Your lordship,
violative.
foreign secrets are also not prohibited item, and plus poppy seeds also not prohibited, your lordship.
Hmm.
It does not come under NDPS Act.
Okay. You make your submissions. First I'll hear it. Does not come under NDPS Act. Customs Act, it violates. No.
No, no, sir. No, lordship. Foreign cigarettes are only permissible item, your sir, with which if they pay the EVIT taxes, they can use that foreign cigarettes, your sir, and it's sold across all over India, including the online platform also, your lordship.
As medicine or something.
No, foreign cigarettes. Cigarettes.
Oh,
They are
foreign
only permissible items, and poppy seeds are used in edible foods like a pastry cakes and all your sir. And most of the Bengali people you keep in a large number of quantities. For like a khaskas or what you call it. Yes.
All right. He was, he has not appeared.
He's appeared.
Yes.
He has replied on Soko's notice, your lordship, on 4th of May. To the additional Joint Commissioner Customs, your Shillong Road.
Number 7.
The department wants,
Not in this case, in some other case, he has appeared in the cigarette and actually there are two cases. In one case, he was granted interim protection as in that was made absolute. In that case, he appeared, but not in this case.
No, your sir. We have appeared in the same case.
May please, your lordship. In this matter, we have appeared. We have submitted our reply in respect of the so-called notice issued by the respondent side, your lordship. And in-
Your lordship, in fact, the
yes.
accused number 7 is already in bail.
Somewhat different, Your Lordship. Here, there are two cases. One was with regards to cigarettes. That Your Lordship was pleased to grant him bail.
this case does not pertain to foreign cigarettes
This case pertains to foreign cigarettes.
as well as poppy.
As well as poppy, 9,000.
That's what he said also. But there was another case separately for foreign cigarettes.
Foreign cigarettes. That he has been granted bail.
You have tagged the gazette notification.
Yes,
Because
everything
that's
is
a
there.
foundation law.
I
Any,
flag mark, Your Lordship, flag mark 2, Your Lordship, is the legal provisions under which he has been arraigned, as well as his involvement is there at flag mark 4, 5, 6, 7, and 8.
Your lordship, there is no concrete evidence, only that phone number they have recovered from
This
this.
is an anticipatory bail application, if I may just remind my learned friend here.
he's, the department wants his custody.
Charge sheet already filed, the statement has been recorded, so no, so what
Charge
is
sheet-
purpose?
Charge sheet also filed.
He is involved in the racket, Your Lordship.
Charge sheet is filed in the form of offense.
Notice, this show cause notice.
So cause notice.
This was issued on 23/2026.
Okay, you make your submissions then. You make your submissions.
So, Your Lordship, basically, since I have that only, Your Lordship.
Uh,
So his involvement is flag mark in those 4,
Flag-
5, 6, 7, and 8. With respect to item number 28, Josna Bose, her flag mark is at flag mark 9. Her involvement.
And the gadget notification, the main law is flag 3,
Flag 2.
flag 2.
Flag 2 and flag 3. As to how poppy seeds are illegal. Flag 2 and flag 3 relates to how poppy seeds are illegal. So I flag mark those provisions as well as the.
Can you give me the page numbers of the?
Yes, ma'am. Anything else?
Yes, your lordship.
Because I have
Actually,
to
he
go
has
through
referred-
otherwise.
Yes, he has referred some pages, your lordship, but I'm sorry, I don't have the reference made by him, your lordship. So may I humbly pay if he suggests me the page numbers, and it will be helpful for
I
me.
can put, sir.
And your lordship, there is a,
Page number, if you write it down, you
Yes.
can give it to me also.
Yes, Your Lordship.
Give me also. I'll tag it with this. Yes,
yes, yes, your lordship, there is a national litigation customs policy, your lordship. The amount which they have mentioned in the summon, your lordship, it's almost like 4 CR. So your lordship, there is 10 accused person. I am not the only one who the
4 CR.
4 CR.
Hmm.
So the submission made by the learned counsel is like that I am the main culprit, my involvement is there, not like that, your lordship.
As per the national litigation policy, your lordship, you can't blame in one person only when there is 10 accused person, your lordship. Now, if your lordship will see the summon, the value, the revenue, if they have mentioned it force here, when the actual government value has to be decided, they have taken it the market value. It is not the market value. It will come under the revenue. And now is the thing that when there is 10 accused person, how he can blame that all the amount has been recovered for me and I am the only person who is responsible for this 4 years, whatever it is, your lordship. Now there is, my friend has already mentioned that there is another accused person, that is Mr. Kamal Sutradhar, which is already on bail. He is also a co-accused person, your lordship, in the same case. When one person.
Kamal Sutradhar, no?
Yes, your lordship. That is the accused number 7, your lordship. I will give you the
He's on bail.
yes, the order of the absolute bail order, your lordship. And your lordship, already the co-accused is on bail. Absolute bail, your lordship. My involvement is only that phone number has been used. They have stated, and most interestingly, the phone number is not in my registered in my name, your lordship. It is registered in someone else's name, your lordship. Only because of that phone number, they are saying that this is you, this is you. How can your lordship? You have to first establish that this phone number is used by me. Without any this kind of forensic examination, anything, your lordship, they have stated that yes, we have found this phone number and it connects to you. That's why you are the main culprit. We need your custodial detention. How can your lordship? First, you have to prove that yes, you are the person. And your lordship, the Kamal Sutradhar AB number is 28 of 2026, your lordship. It's Gada Didi Bosan.
Stapler লাগে stapler এতিয়া নালাগে সব লাগে মানে দৰকাৰ co-accused, right?
Yes, your lordship. He is already on bail. When the co-accused is already on bail, I am also entitled to get the privilege of the bail, your lordship.
If the factual things are situation is similar, then parity will come.
Similar, your lordship.
Then
Similar.
parity will come.
Yes, yes.
Otherwise, not.
Not on parity. Here, they
You
are
deny.
on the same footing.
On the same footing, your lordship. Same accused, same so-called notice, your lordship. And photo may I have appeared before the DRI, your lordship, submitted my reply. I have complied everything. Now, maybe my learned counsel does not have the instruction that whether I am appeared or not. But yes, your lordship kindly record my statement that on 4th of May, I have duly appeared and I have submitted or reply in the so-called notice issued by the respondent, your lordship.
Okay.
And I am ready to cooperate, everything, your lordship. And in respect of page number 977.
Yes.
Yes. Now, if your lordship will they see page number 77 of the so-called notice they have issued. As
Page
per-
77 of the so-called notice.
So-called notice, your lordship. Page number 77, my learned friend had stated that they are not on equal foot. That is Kamal Sutradhar and Himanshu Bose. Kamal Sutradhar is already on bail. So if your lordship will see page number 77, your lordship will find that both are equally. That is, here one point they have mentioned from the report dated so-and-so, the bank account number so-and-so and so-and-so were obtained. So my bank account as well as his bank account has been obtained equally, your lordship. Then I am on in the same footing, your lordship.
His bail order, you can just send it later. The bail order of Kamal Sutradhar.
Yes, your lordship.
If it is not annexed, you can submit it.
Yes, definitely. I will give it.
You can give it to me.
So
So that's all. I'll close. No. But I have to go through and see it.
your lordship.
Himanshu Bose also.
Himanshu Bose is the main. Item number 29.
Yes.
Item number
28
28.
is the wife of Himanshu Bose.
No, no, no. She's
In
already
whose
on
name-
interim.
In whose name
Yeah.
She's already on interim, your lordship.
Thing was
These are the
raised.
submissions are with regard to Himanshu.
CDR record actually.
Rightly given interim, that can be disposed of. It can be disposed of, perhaps.
Lordship, I have a simple,
Yeah,
simple
not-
prayer, your lordship.
Not complete.
Finally,
Yes,
I record my statement that your lordship, he has already appeared.
I have
before the
written it
hearing.
down.
Yes, yes.
Yes, I
Oblige, your
appeared and submitted reply.
On 4th of May, your
Yes,
lordship.
yes, on 4th of May
Yes, your lordship.
of 26.
Oblige, your lordship.
This is the last one.
So, story বলে, yes. কিমান নম্বৰ দিলে এতিয়া? কিমান নম্বৰ দিলে? 39? 33 or 35%. কৰি দিব লাগিব। Timing আছে নেকি? No, no, নাই, আজি নাই। কাম আছে মোৰ। এইটো, bill কেইটাহে কৰি- Yes, please.
My lord, here, my lord, CD was called for in the earlier occasion, my lord. We have received the case there, but without FSL, my lord. The NDPS quantity, my lord, intermediate quantity. And otherwise, my lord, the contraventions are recovered from his house, my lord.
It is, my lord, actually not the house, my lord, not specific, my lord. Only money was recovered from the house, my lord. FIR is at page 14, my lord. In fact,
He's in custody since?
no, my lord.
No,
after
AB,
3 years,
my
my
lord.
lord. 482, my lord.
Maybe,
NDPS AB, my lord, how it is maintainable, my lord.
no, I mean, nothing is impossible if there are reasonable, if there are materials that he's not linked at all.
But here
Then
FSL,
it can be.
FSL is pending.
Otherwise
Consumer
difficult.
call for FSL, my lord. Up to date CD along with FSL, my lord, after vacation.
Will that do?
Yes, my lord.
Counsel for the petitioner. Sorry, full stop. The case diary has been received. However, the FSL report has not been received. Full stop. You'll retain the case diary?
My lord,
Retain the case diary?
send back, my lord, after vacation, my lord.
The
Along with-
additional PP submits that perhaps while returning the case diary, the FSL report may be procured for adjudication of the bill petition. The say prayer is allowed, full stop. Call for the FSL report
Up to date.
along
CD.
with the up-to-date case diary. Full stop. For this purpose, the case diary shall be returned and procured again
My lord.
for the
Twen-
next day. List on
22nd, my lord.
22/7.
But is it on 22, my lord? 22/7?
22/7.
22.
Yes, yes, deeply on that.
Okay.
My lord. Thirty-three, my lord, CD not received, my lord. CD no.
The case diary is not received, full stop. Issue fresh requisition for the case diary of South Salmara PS case number 28 of 2026. List the matter on
My lord, 23rd, my lord.
23/7. Okay, 23/7.
My lord.
My lord, here is a case of absolute 500 condition, lordship. Lordship, here we have annexed each and every document. First, lordship, I have placed this annexure.
A copy of the file, my lord, I have not yet received.
uh, Lordship, here, a case was registered on 14. First, Lordship, I'll draw your Lordship attention on page 24. Page 24, the first affair. wherein petitioner was implicated. That is page 24.
You have a copy?
No, well, I have.
Copy has been served to the PP
But
office.
well, because that was mentioned unlisted, so my lord.
Should we wait for,
Yes, my lord.
make our submission?
Uh,
She can make our submission.
Yes.
Yes.
Otherwise,
Lordship.
Lordship may fix it day after tomorrow, well, no, no, tomorrow, well.
So, let me go through the FIR.
Yes,
yes.
She wants to see.
So this
24.
Lordship, this affair has been lost.
Ah.
Page, it starts from page 24, Lordship.
Mm.
Jalukbari PS case 185. At page 24.
Mm.
Page 24 was, I'm placing the short gist, Lordship. The gist is such, 4% appeared before Jalukbari police station stating that their money has been stolen by somebody. Then that 4% has been detained in the police station for placing false information. That is the crux of the matter, and wherein the petitioner also, this present petitioner and another person and both the petitioner also dragged in, stating that some illegal cattle is going on. That was the then at the instance of the petitioner, that false information being given. So this honorable court, after verifying all materials, after perusal of the case diary, Lordship would be pleased to find that those 4% who has given false information, that their bail application has been considered. Page 28, Lordship. The bail application of the person who has primarily appeared before the police station stating that our money has been stolen. Lordship got page 28.
I'm on 28, yes.
28, no?
28, 29.
28, the operative portion, the operative page 30, learned so and so, serious objection stating that role the conspiracy consider so and so, have considered submission of the petitioner, have also considered so and so, foregoing discussion, and then so bail, ultimately 30,000 bail has been granted to this petitioner, and subsequently 4%, other 3%, Lordship, page 32, in this case, Ken Chaudhary sir appeared and he placed his argument, and accordingly their bail also considered. Thereafter, Lordship, then petitioner bail was not regular bail, it was an anticipatory bail, Lordship. That is page 38, Lordship. Page 38, Lordship.
The petitioner is
Mahbub Ali and Ajmal Ali. Ajmal Ali. Page 39, Lordship. So page 39, I'm placing it, Lordship. This is the content, Lordship. Second para, this is an application under 482 of the Bharatiya so and so, praying for granting PRS bail to the petitioners, namely Mahbub Ali and Ajmal Ali, who have been apprehending arrest in connection with the Jalukbari police station case number so and so, registered under section so and so, read with so and so. Affair in connection which petitioner were charged under aforesaid section was lodged on 22/5/2000. It was revealed by the said affair that 21/5 at about 11:30 a.m. the incident informed that 5 youth in a Bolero vehicle robbed rupees 25,000 while they were coming from Shillong. Said robbery stated to have been done 2 persons coming from a Bolero vehicle who impersonated themselves as crime branch officers. It was also stated in the said affair that said money was in connection with hiring charges of excavator charged in a work site near Umsing. It is therefore stated in the affair that pursuant to the said information, an inquiry was conducted and 4 so-called victims, that is the bail application, whose bail application has considered by this honorable court, victims were examined, and on examination contradiction appeared in their statement. On further examination, it was found that amount of 21,85,000 was proceeds from illegal cattle smuggling. That was false robbery story was projected by the said victims. It is also stated that apart from the said so-called victims, 2 other individuals who were involved in involved and further that the petitioners have had the entire conspiracy. It is also stated in the affair that the petitioner were also present in the Bolero vehicle where informants, that is 4% were present, that petitioner had fled from scene. So and so senior counsel submits involvement of the petitioner was incorrectly made as they were not there in the Bolero vehicle in question, and their entire story is cooked up story. He submits that at best it can be a case of wrong information, but the registration of affair under the aforesaid section of law against the petitioner was not correct in the eye of law. so-and-so learned so-and-so revealed that conspiracy was held by the petitioner to misappropriate entire amount. He also placed a statement of co-accused who was initially informed.
Anticipatory.
After that, Lordship, the bail application, and up now page 41, Lordship may kindly say, kindly peruse page 41, that petitioner shall appear before investigating officer within 10 days, failing which on the 11th day, pre-arrest bail order shall have no force. So accordingly, Lordship, this order was passed on 12/6. Lordship got there. Page, that is, it starts from page 39. So 12/6 this order.
I'm on 14.
Immediately
41.
after, this was nothing, Lordship, a ego clash between the police and the things, Lordship. On 12/6 onwards, after the order was passed, they were constantly appearing before the IO in question in the pretext of these or that, saying that I am engaged in Kamakha duty. I cannot record your statement. Ultimately, finding no other alternative, Lordship, they appeared, they again appeared before the police station on 19th. I have also given a receipt by the police, Lordship. I have, that is at page 42, Lordship. That petitioner were duly present in the police station. And that particular time also they have not disclosed pendency of any case. Thereafter, when on that they have called that Saturday, that is on 20th.
You were
20th.
arrested in another case.
Yes, on that day, they, after accepting bail bond and all, they have arrested in the present case, Lordship. Now, Lordship, I am placing the seizure list. The seizure list I have annexed to this petition, Lordship. The vehicle, the cow have already been seized from other person, 4 persons. That was also registered under the same police station. So they dragged in to frustrate the bail of the present petitioners. This they have dragged in the instant case. Lordship would be pleased to find that the season list at page 19, Lordship. Lordship got to page 19.
Again, it is BA, my lord.
Page 19.
And if what I can understand, my lord, because earlier, my
Just a
lord,
minute.
this is BA, my lord. So my prayer before lordship at this stage CD may be called for. What I can understand, my lord, against the present petitioner, earlier also one case registered before the Jalukbari police station. My lord, if
He got anticipatory
in that
bail.
case, my lord, he is the main person who created a fake, my lord, dacoity case, my lord.
That is,
If I can remember, my lord, in that case,
I may be allowed to. I may be allowed to.
Thereafter, my lord,
I may be allowed to
four
submit,
persons were
Lordship.
arrested, and this
Because
Rahubali, who was the main
I'm taking it up, but he doesn't have the copy now. Please
yes,
get
my
the
lord.
copy.
Because earlier, my lord, I have
get the
done so
copy.
one of the petition. That's
You
why
complete your submissions. You complete your submissions.
Yes,
Lordship.
If necessary, you'll fix it tomorrow, but you ask the office to get the
yes,
copy.
yes.
You complete your submission.
Lordship.
Madam, you complete your submission. So I come to now page.
Lordship, page 19, Lordship. Page 19.
The instant FIR.
No, page 19 is the season list. Lordship.
Because
what are the materials has been seized and from whom it has been seized? Page 19, Lordship.
No, because he has been arrested. He has been arrested in connection with which case?
In case that is FIR number page 13.
Just a minute. Jalukbari case number?
213.
Number 213. Of
213, Lordship.
2026. The FIR is just, let us see the FIR of this.
Yes,
I'll come to the seizure list.
Lordship, page 14. Page 14, Lordship.
Place 14.
I respectfully submit 13/6/2000 at about 11 AM while performing patrolling duty under jurisdiction of Jalukbari OP. Reliable source of information was received that certain persons were illegally transporting cattle through Jalukbari towards Meghalaya in violation of the provision of law. Acting upon the said information, a Naka checking operation was immediately conducted near Saraighat Bridge. During the course of checking, 2 boleros number so and so, these 2 intercepted subject to lawful search. Upon search, 10 cattle were found loaded in Bolero Max pickup AS01 so and so. 9 cattle are found loaded in vehicle Max AS25 8331. The cattle were found to be transported in an overcrowded, cramped and cruel manner without adequate space for movement, proper ventilation, food, water, and other mandatory safeguards prescribed under law. The manner of transportation was such so as to cause unnecessary pain and suffering and distress to the animals. During inquiry at the spot, it was revealed that the aforesaid cattle were being transported from Senga, Borpeta and Nalbari respectively towards Meghalaya via Jalukbari. The drivers and co-drivers of the vehicle were asked to produce valid permit, transit passes, veterinary certificates, ownership documents, and other statutory documents authorizing transportation of cattle. However, they failed to produce any such documents, valid document in support of their transportation. The facts and circumstances disclose that the accused persons were transporting cattle in contravention of provision of Assam Cattle Preservation Act 2021 and were subjecting the animals to cruelty during transportation. There are sufficient ground to believe that the accused person were engaged in illegally interstate transportation, trade of cattle, violation of law.
And
And the seizure now, Lordship.
and the case in which they had got bail, that was
regarding
Jalukbari 185.
185.
Just a minute. Jalukbari 185, because for me the facts are new, right?
Yes.
So, Jalukbari 185 of 2026 based on FIR dated 22/5.
22/5.
Right.
Yes, for giving false information before police. That is a totally different aspect, Lordship.
In that case,
In
Jalukbari 185, they got anticipatory bail.
They anticipated bail after perusal of the case diary. After consultation, all persons, those who place false information before police, they have been arrested on the spot. They have enlarged by this honorable court. Subsequently, these petitioners were given privilege of pre-arrest bail, and the IO, these pretext, that pretext, avoided to record their statement as there is a strict direction that on the 11th day, this bail order will have no force. They had no option but to visit the police station repeatedly. On that day, after completing all formalities of the bail bond jima, they have been taken in custody in this case, Lordship. So now, Lordship, I am placing a vital document, Lordship, that is at page 19, Lordship. Lordship may kindly come to page 19. What are the materials seized? Description of the seized article, Lordship. One Bolero Max pickup, so-and-so, AS01TC 0311. Red color cow, one white brown color bullock, 7 numbers of red color bullock, 1 number of reddish black color bullock. Then next page, Lordship. Next page, Lordship. So cows a cow and 2 Bolero car. Now, Lordship, I am placing a JIMA application was filed before the trial court at page 21, Lordship. 21, Lordship may kindly be seen 21. My application, page 21. Lordship.
Yes, sir.
Seen the prayer made by IOS in the original seizure white memo so-and-so along with the photograph of the seized cattle and 2 vehicle registration number 0311 and so-and-so. Peruse the case record so-and-so. Perusal, prepared list of materials so-and-so, so-and-so, so-and-so. Seizure list, sign witness above named. Then I am satisfied mandate provision of so-and-so, so-and-so. Then these 2 vehicles, these articles were seized. Later on, Lordship, page 22. Later on, Lordship, page 22. Below part, Lordship. Below part. Here, bail application of those who arrested driver and event from whom the vehicle has been, their bail application has not been considered by the court below. Then later on, seen the JIMA petition filed by the petitioner Omar Farooq, Amjad Dewan and Pavitra Rajbongshi. The petitioner Omar Farooq by petition number 1602 has prayed for custody of 10 numbers of cows. The petitioner Amjad Dewan by petition number 1603 has prayed for custody of 9 cows. That is 19 cows. Owner has come up before the honorable court stating that I am the owner, Lordship. Then the cattle of and 9 prayed for 9 numbers of cattle, and petitioner Pavitra Rajbongshi by petition number 160 prayed for custody of the vehicle, Lordship. 2 vehicles has been seized. So AS25 FC 8331 Bolero Max pickup. So he is the owner. Then stating that they are the lawful registered owner of the aforesaid seized cattle and vehicle respectively. Perusal of the case, 19 numbers of cattle and vehicles bearing number so and so have been
have been shown to be seized by IO by so-and-so hardwood report from IO so as to whether petitioners are lawful owners. Then, so this was placed, Lordship. Accordingly, it was well aware the knowledge of the investigating team that petitioner, this present petitioner, neither the owner of the vehicle nor they have found in the vehicle, nor their cows, the owner have come up, that aspect has been unnecessarily just to frustrate, just for the ego purpose, Lordship, just to frustrate the bail application, the anticipatory bail, which has been granted by this honorable court, the present instant case that they have been. So this is very high-handed action, Lordship, abuse of the process of law. That should not be this petitioner here. He's a very bona fide citizen.
I can produce the CD day after tomorrow.
Let me
I
complete,
can produce
Lordship.
the CD day after tomorrow.
Let me complete, Lordship.
Because
Lordship,
highly-
this is a very high-handed action. This way, citizens' liberty cannot be taken away, Lordship. Just to frustrate the bail, this entire process has been they should be given a lesson, Lordship. And this is the trend have come up, Lordship. This is very unfortunate, Lordship. This petitioner, they have himself, their
The
relative.
allegation against them is that the police says that they are indulging in illegal cattle trade.
Yes.
And the dacoity was
Dacoity, my lord,
falsely staged.
regarding that, the dacoity, my lord, case, my lord, as I can remember, my lord, because earlier in the motion,
Can I?
most
for a
of my
moment.
lord, although I have not gone through, there are total 6 persons. They were, my lord, my lord, in front of the, my lord, Edison Blue, my lord. Some of the accused persons, my lord, my lord, one of the informant of there were, my lord, 6 persons in a Bolero vehicle. Later on, one of the, my lord, informant informed the Jalukbari police station that in front of the, my lord,
Radisson Blue.
Radisson Blue, one dacoity case, they were, my lord.
They were subjected to dacoity.
Dacoity, my lord, subjected to dacoity. On that basis, my lord, thereafter police inquired, my lord, during inquiry, police came to know that only to, my lord, because there are total, my lord, thereafter police recovered also, my lord, more than rupees, my lord, 19 lakhs, my lord, from them. And during at that point of time, only to, my lord, misappropriate that amount between the class between them, because those are monies from the, my lord, illegal, my lord, cattle business. And one of the accused person, there are total 6 persons in that Bolero vehicle, and out of the 6%, 2% fled away from the spot, and that is one of the present accused, Mehboob Ali. And during investigation, they have done, my lord, they have falsely, my lord, impersonating 2 police personnel, my lord, blaming police personnel that police personnel are involved in committing dacoity, my lord. And thereafter, my lord, during investigation, while police found that, my lord, that entire allegation is false, my lord, and thereafter, my lord, police lodged FIR against these accused persons. And although, my lord, they obtained, my lord, interim protection, my lord, in that case, my lord. And now in this
They
case,
got anticipatory bail.
Regular anticipatory bail, Lordship, he is placing the totally fact which is not tally with the record, Lordship. No recovery has been made. This is a clear order from this honorable court. He's placing the wrong submission just to mislead this honorable court, Lordship.
I'll have to see then.
The order is there. I read the order just now. I will reiterate the fact again. I have annexed the order, Lordship.
Can you get it tomorrow?
day after tomorrow, my lord, Jalukbari PS, my lord, I can get it.
Tomorrow? Try tomorrow.
Tomorrow probably.
Because court's direction is that telephonically can you instruct?
Telephonically, but my lord,
Because last day is always risky.
Day after tomorrow, my lord, I can, my lord, certain that I can get it, my lord. Otherwise, then.
Are you agreeable the day after tomorrow?
Lordship, absolutely illegal detention, Lordship. I should come by habeas corpus petition, Lordship. Absolutely. No connection. Owner is there. Cattle owner is there. Vehicle owner is there. Wherein I came, Lordship, they were trying to delay my case, just to register a case, just to frustrate my bail application, Lordship.
Okay. So anyway, that contention has been made. Kindly get it tomorrow.
Yes,
Get it tomorrow. Okay.
Then day after tomorrow, Lordship.
Not tomorrow.
yes.
No, you have some difficulty tomorrow?
I have
Yeah.
some. We are going to Kohima bench, Lordship.
One day
Traffic.
you come back.
On 26/6.
Be taken up at 2 p.m. Lordship, because
We'll
it's
take
not
it up. Don't
weekend.
worry. Will all matters on 26 will hear it. Here, we
Lodge-
manage.
I'm so grateful for
No, no,
giving
no,
me
no problem. No.
accommodation.
But I know I've understood, but of course you have read the file thoroughly, but for me it is,
My fault,
for me it is
better
new.
understanding, I have given
You,
all
huh?
that.
I am only
You
stating.
go
the-
through it.
Yes, I am
Go-
only stating the fact, otherwise, how this accused person is
Heard.
involved, only from CD I will get.
And council, T. Soap, learned post of, it is submitted, I just want to that the petitioners that secured anticipatory bail from this court in Jalukbari PS case number 185 of 2026 with conditions, one of which was appearing before the IO post of. However, subsequently, they were arraigned as accused in Jalukbari PS case number 213 of 2026 unfairly and arrested. Or they were arrested on
On 20th Lordship,
20.
20.
206, 2026. The Som Learned Council submits that the arrest and detention of the petitioners was illegal in as much as it was solely done to circumvent the relief obtained by them in the secured by them from this court by way of anticipatory bail in the other case. Full stop. Nevertheless, the learned additional PP shall procure the case diary tomorrow.
Day after tomorrow.
Day after tomorrow, day after tomorrow.
Fixed on
Yeah.
26.
26. We'll take it up in that. All
26.
matters, 26, all matters will be taken up, at least all liberty matters.
Highly up.
It further. Anything else left? Any bail left? Time being? Okay.
Timing item 6.
I can just quickly, if you are there, we can, otherwise we'll fix it. POCSO is there, POCSO. None appears on call. Scan record is available. This is the matter on 15.
Yes.
15/7.
I just beg Lordship indulgence. There may be every possibility that they will not produce CD. My apprehension, Lordship. In that case, my bail will be considered on the material
That
available.
is in my mind. Yes, that I'll see.
Lord.
I'll have go through the file properly
Lord.
and pass an
Lord.
order.
Lord.
So you get the case diary. A court has directed while not.
How
produced.
he can make.
No, Lordship.
This is, don't be so apprehensive. Law is there, court is there.
Lordship.
We should be, whatever it is,
Yes,
in
yes.
a steady manner, we should hear.
Yes, yes.
You get the case diary.
Yes, I will get it.
You get the case diary. Say the court has directed, you get the case diary.
13. Timing item 13.
List on 15. This scan record is there. Is it a POCSO matter? Otago? Notice, not yet given.
16.
As per the scan record, TCR has been received. However, as per office note dated 28th June, service report is not yet received. The prosecution shall take instructions regarding the service on the respondent through the concerned police station. This is the matter on 15/7.
Yes.
Not tonight. Okay. I'm taking some medical leave actually, second half.
May I please, Your Lordship? I sincerely apologize.
No problem. Wait, which
Petition number 36, Your Lordship. It's been pending since 2014, Your Lordship.
Yes, yes. What is the matter, this one?
Your Lordship, I was convicted under section 138 of the NI Act,
Mm.
Your Lordship, and the pending amount was 1,50,000,
Mhm.
and subsequently 1,30,000 was paid at that time.
Why has it come up for orders?
Your Lordship,
Isn't it ready for hearing?
no. The service has been completed, Your Lordship.
We can post it for hearing immediately
Yes,
after
yes,
vacation.
sure.
Fix a date.
Lordship,
Automatically, it will come on in the top of the hearing list. And
Can
if
it
not,
be-
we can fix it at 2 o'clock someday.
Lordship, can it be tomorrow or the after tomorrow?
No,
It's a
difficult.
matter of 2000.
Because you're on bail, no?
No, yes, sir, yes, sir.
He's on bail. Then you have to, because there may be other more pressing matters. Every matter is important, but there may be more pressing matters. Of course, matters should never remain pending since 2014.
Completely.
No matter should remain pending.
Completely.
Mr. Upreti, so if any intermediate steps are remaining, that we must do during this time, so that after vacation at least it is ready for hearing. So why, that's why I asked, why is it coming for, why is it come for orders?
So this has been completed, Lordship. Lordship, and I had called for the records, Lordship. We have filed an affidavit of thus the survey has been completed.
Mr. Upreti, Learned Counsel submits that the matter is pending since 2014. And full stop. The revision has been preferred against concurrent findings of guilt, right? Conviction.
Conviction.
Conviction. Concurrent findings of guilt with regard to proceeding pertaining to bouncing of check. Within bracket NI case number 5 of 2010. It is submitted that justice service was resorted to with regard to the respondent/complainant, and compliance affidavit has also been filed. However, none has appeared so far on behalf of. Now I understand. Record has not come.
So, call for the record was done.
Record was called for.
Yes, sir, Lordship, today.
I see.
Lordship, I have an extra copy, Lordship.
No. We'll. Huh? No. Affidavit is there. Affidavit I have. No, I'm saying the original TCR.
See, no.
Unavailable. The call for the original TCR, comprising both the trial court record as well as the appellate record from the learned trial court. That is, it was check code. Which was the learned trial court? Can you help me with that?
Yes, sir.
How come the record has not come so long?
Session code Gauhati, Lordship. Page 16.
The complainant has also been substituted, I think.
Yes, sir, Lordship.
Substituted also. From?
Respondent, Lordship.
Respondent. So additional CGM from the trial court.
Yes, sir, Lordship. Trial court.
Let me also cross check. SDGM as
Gauhati.
5 of 2010. As the matter is all pending, the TCR in original may be transmitted expeditiously. A copy of this order shall be sent to the learned trial court for the needful. At least should we fix a date?
Yes, sir.
We'll have to fix in order column only, because the record has to come. Immediately thereafter, you'll get a hearing. Don't know.
Can it be on 15th of July?
No, it may not come. Let's take a. Today's the 3rd. Let it be on 23rd. 23rd. 23rd, 23/7.
Oblique, Lordship.